Take seats, please.
Please rise. Justices of the Appellate Division, Supreme Court, First Department. Hear ye, hear. All persons having business with the Appellate Division, draw near, give your attendance, and ye shall be heard. Please be seated.
Good afternoon. Welcome to the Appellate Division First Department. I think most of you know the rules in terms of how we proceed. Let me just reiterate that when I call the calendar, please request the time that you believe that you need for purposes of argument. Please keep in mind that we are fully familiar with your briefs. We've read the briefs. We are familiar with your arguments. So again, please just request the time that you believe that you need. And please also keep in mind that, in the real world, you could request all the time you want, but this is not the real world. And someone left this paper on here that says it's over 5 hours of argument time requested, so that's a no. Okay, so I'm going to call the calendar now. People versus Evan Wald. 6-2 and 6. Sanchez v. Walton. 5-2 and 5. Adriana K. versus Gregor K. We don't have an appellant. Did you wish to submit? Okay, like 3 minutes? Okay, 3 minutes. Submission in 3. OSI LLC versus New York State Division of Housing. Appellant? Did you wish to submit, or did you want like 3 also? Good. 3 minutes. Paz versus 565 Equities. Justice Friedman is recused on that matter. 6 and 2 and 5. People versus Curtis Hill. 5-2-5. Arena Investors versus Capstone Capital. Submitted.
Oh my God.
I'm sorry, was there someone here? No, submitted. People versus Avell Nelson. Submitted. Fisher versus VNL 225 West 58th Street. You have a cross appeal? Yes. 5-2-5-2. Rudderman versus New York State Insurance. 5-2-5. People versus Cornell Sims. Submitted. Vakari versus Shea. No respondent. Did you wish to submit? No, I'd still like to argue. 5. Morris versus New York City Law Office. I believe, yes. We do not have an appellant. I'm sorry, we do. I apologize. Yes, you are. Appellate respond, it's all the same. Don't worry about it. Okay. 5-2 and 5. Dyer versus SUS Foundation. Submitted. First matter for argument is People v. Evan Wald.
Good afternoon, Your Honors. Jan, host for Appellant Evan Wall. Because Dr. Schmitty did not perform the autopsy, and in fact was not even present when the autopsy was performed, her testimony, as well as the admission of the autopsy report, was improper.
So our prior case law on this matter states that would be, the testimony by Dr. Schmitty would be non-testimonial and therefore would not be a violation of Crawford or the right to confrontation.
Yes, but the Second Circuit has made it perfectly clear in Garlick that both the Court of Appeals decision in Freycinet and this court's decision in Ortega are not founded on established Supreme Court law, and therefore any case now being appealed would be subject to a winning habeas because it's in violation of established Supreme Court law. There is no longer a Crawford exception for autopsy reports that merely state observable facts.
But even after the Second Circuit decision, have we not still adhered to Ortega?
Well, if this court feels that it should still be following the Court of Appeals case, then we would, then I would respectfully request that you hold off and wait, because the Court of Appeals did grant leave in Ortega in light of Garlick. So presumably they're poised to reassess their position. How that comes out is probably preordained, but you may disagree with my assessment of where that's going to go. So again, if you feel compelled under your own law and the Court of Appeals law, then we respectfully request that the appeal be held in abeyance until Ortega is decided. My understanding, it is fully submitted, so there's...
And you mean we're talking about the U.S. Court of Appeals?
No, I'm talking about the New York State Court of Appeals granted leave, in
You're
Ortega.
suggesting that they're going to change, that they're going to step back from what they've held before.
Yes, I do believe that in light of Garlick, they are going to change their assessment of what qualifies as testimonial and what does not. Again, the Second Circuit's made it perfectly clear that what this court held in Ortega and what the Court of Appeals held in Freycinet is not founded on established Supreme Court law. They completely reversed those decisions, even though they don't have the power to actually reverse them. They've made it clear they cannot stand.
So in terms of Dr. Schmitty's testimony, did she not just basically testify as to what was contained in the autopsy report?
Well, that would be, I believe, a reference to my adversary's point that this was harmless, which is simply another way of saying that it was not testimonial because the report was merely reflecting observable facts. But it was harmful. Even though the report did not say which particular wound was the lethal wound or how many could have been lethal, if you look at the prosecutor's summation, he used it extensively to argue that the amount of wounds, the depth of the wounds, clearly indicated that my client was guilty. Because after all, according to the prosecutor, it not only had to be somebody who knew the deceased, but somebody who hated him, because why else would they have viciously attacked him this way?
And we're talking about 48 stab wounds, right? 48 stab wounds?
Yes,
stab
Your Honor.
wounds. And, he also slit his throat. And also, the decedent's throat was also slit?
Well, there was a wound across the throat. Slitting your throat is a characterization included in the autopsy report, which should only have been testified to by Dr. Greenbaum, or Greenman, I'm sorry, I can't remember.
Theoretically, in a case such as this, with so many stab wounds, this could be a harmless error. I understand you're saying it's not under the facts of this case and the way it was utilized in summation, but it could, you didn't need this autopsy report to establish that the victim was killed.
You didn't need the autopsy report to establish that the victim was killed or that the victim was killed as the result of multiple stab wounds. However, the district attorney in this case needed that report.
You're saying they used it in a way which takes it out of harmless error analysis.
I can only deal with the case in front of me, and whether or not there is a case in the future where there would be an appropriate harmless error analysis, this is not that case. Again, read the summation. There's so little evidence establishing my client's guilt, much less there's no evidence at all to suggest that he so hated the deceased that he would have stabbed him 48 times. He made a comment that I'll kill him if he hurts my sister. But what brother hasn't made that comment about a spouse or a boyfriend of their sisters? It doesn't indicate the amount of rage that went into this crime. For all
Wasn't there also testimony concerning your client's ambition or belief that he was going to work at the company, or that he was going to work at the business?
he did work at the business.
And he was going to continue to work at the
And he was
business?
going to continue to work. I think what Your Honor is referring to is he was hoping for, whether it was considered a promotion or
Right,
not, but maybe
yes.
a different location or something, and he wasn't going to get it. But again, I think
Because he
everybody,
worked at the diner, didn't he? Didn't he work at the diner?
I think it was a coffee shop.
I'm sorry, he
I think-
worked at the coffee shop, but then he believed that he was going to be working somewhere else or in another position at the coffee shop?
I think the deceased owned several coffee shops.
Right.
He had worked at one, he was now working at one in the building. I'm not sure if he thought that there was a promotion, so to speak, or just simply a different location. But
And
he-
after the incident, didn't your client exhibit or have, his hands were swollen, I believe, and he also had cuts on his hands, which would be consistent. His hand was bandaged, and he also had multiple cuts, which would be consistent perhaps with wielding a knife?
Okay, Your Honor, he had a cut. He had a single cut, not multiple cuts. And
I thought the testimony was multiple.
no, it was one single cut that, yes, he
But
had
his
a
hand was
bandage on.
bandaged, wasn't it? His hand was bandaged, wasn't it?
Yes, his hand was bandaged, but he did,
I know that your red light is on, but what did the DNA evidence show in this case?
the DNA evidence in this case showed absolutely nothing. There was a spot of my client's blood on the wall, but again, he worked in the building and he worked in the food industry, he served breakfast, bagels, etc. One small spot. There was DNA evidence found in the bathroom, but all that proved is whoever the assailant was cleaned up because it was the deceased blood. Interestingly enough, my client, who supposedly stabbed the deceased 48 times, there was no blood on his clothes, no blood in his car, no blood anywhere, so
But there was a speck of blood on the wall next to a lot of blood from the decedent.
a lot of blood from the
And there apparently wasn't there a large time gap between when the decedent was killed and when his body was found? Wasn't his body found like the next morning?
Yeah, his body was found at around 5:30 in the morning.
Right, and the thought was that he was killed earlier in the evening.
That was the thought, but I'm not
The
sure.
argument put forth by the people was that he was killed early in the evening, perhaps after they went to the gym, right?
Correct,
And before he was allegedly going to the Knick game, or whatever game at Madison Square Garden.
correct, correct.
Thank you.
May it please the court, I'm Philip Tisney for the respondent. I'd like to start with my adversary's argument about the weight of the evidence. This was a circumstantial case, but the proof was very strong here. In addition to the compelling evidence of motive, the defendant and his sister were the last two people to see the victim alive in the very short window of time before he was murdered. They were the only two people who were there at the time. They had no reason to be there.
So, counsel, you had all that information. Why did it take so long to prosecute this case? And then I want you to address that in light of the Court of Appeals' recent case
in Reagan. Well,
Yeah, so this incident occurred in 1999, and the defendant was not prosecuted. He and the co-defendant were not prosecuted until what year?
2017 is the conviction, or I'm sorry, 2017 is the indictment. I believe the crime is 1997.
Actually, I'm sorry, it was 1996.
So I dispute the contention that all of the evidence that they had against the defendants they had as early as whatever it was, 2002. The people and the NYPD continued investigating this crime pretty much continuously until the DA's cold case unit uncovered new evidence in 2015, 2016 that prompted them to go to the.
So what was that new evidence? They re-interviewed some individuals. I think they re-interviewed the babysitter.
They re-interviewed the babysitter who gave them new information that showed that the account that the defendant and his sister had given to police conflicted with an account that the sister gave to the babysitter that night. The babysitter also described circumstances that occurred the night of the crime when she got back to
They lost track of the babysitter? Why such a long time to re-interview the babysitter? Was she gone, for example, and couldn't be found?
She was out of the country at some point for several years. She had returned. She was interviewed originally and gave information. She just was re-interviewed as part of the reinvestigation of the case and gave additional information that they hadn't had before.
So what do they do over the 21 years?
What is, I'm sorry.
What was going on in terms of investigation during these 21 years?
Well, as we've set out in our papers, as the affirmation set out in the court below, there was a continual investigation that occurred throughout that time. There was an initial investigation that occurred over several years. After that didn't lead to information that either the NYPD or the people thought would be prosecutable.
So what concretely was done to investigate over those years?
I don't have them to hand. I mean, so for instance, there were blood samples taken from the scene that were tested back in the day. Back in the late '90s, the DNA testing was not nearly as good as it is now, and so those samples were resubmitted again later. They were submitted to federal prosecutor or federal investigative authorities later to see if new investigative techniques would yield additional information. They didn't.
So that was in 2002, correct? When
They were pursued, yes. These were
Oh, okay.
additional avenues that were
And
pursued.
It seems clear to me that the first few years that there was an investigation, really, in my mind, if there's a blank, it's after 2002 for a period of time, that it's not clear to me from the record what occurred.
Well, and as
Is
the
that a
trial,
fair characterization?
yes, and as the trial court recognized, there were periods of time in this case where the investigation sort of ebbed and flowed, I think was the exact term that the trial court used. Now, you have to understand the reason for that is because people were investigating the crime and felt that they had come to either the end of their investigation or a dead end in terms of what they could prove. But that's a fairly significant difference from the kind of thing that the Due Process Clause protects against, which is not just the lapse of time. It's really protecting against prosecutorial bad faith. And I think that's what you see in the Reagan decision. It's not the length of time that's important. It's the explanation for the delay that's given. And here,
So there's
really
the admission, is it the admission there? Is that the difference?
I mean, it's partly the difference. I mean, there was no explanation for the delay, and that was a relatively.
Well, actually, they conceded that they were incompetent in Reagan.
Well, I don't know precisely what the facts
Well,
were.
they-
I thought reading Judge Wilson's decision, he had said that there was no explanation, or at least no
Well,
justifiable
the
explanation that had
issue
been
was
offered.
why they did not, in Reagan, the issue is why they did not make any attempts to get to obtain a DNA sample from the defendant.
A world of difference from this case. I mean, there you have a victim who, on the day of the crime, identifies the defendant, gives her own, DNA sample. All the police have, and the police interview the defendant that same day. All the police have to do at that point is get the warrant for the DNA swab, which they wait inexplicably for 3 years to do. Now, you put
Counsel,
that
would
kind
you
of.
agree that there appears to be large periods of time where, let's say about 2 to 3 years, where it appears that no investigation was done?
I think that's a fair characterization, but again, I don't think the fact that no investigation occurred is dispositive or shows bad faith on the part of the people.
My
think what it
understanding
shows
is also that as of 1998, for the most part, most of the witnesses had been interviewed. Did that include the babysitter and who was it? And the victim's mother?
It included the babysitter. I don't know if the mother was interviewed. It
And
did
there was
not
something
include.
about the matrimonial attorney, right? Because the co-defendant allegedly was actually, that the marriage was not as she had characterized it, and there were actually issues that there was marital discord.
Precisely, Judge Weber. It did not include the marital attorney. It did not include, I think, critically, the friend of the victim who testified that he was supposed to meet the victim at 8 o'clock.
With regards
watch-
to the marital attorney, if I just may ask, my understanding is that that person's name appeared in the victim's 1996 date book. So why wasn't she interviewed, or I think it's a she, why wasn't she interviewed before December of 2016?
I don't have an explanation for that. What I can say is, in retrospect, certainly, 2020 hindsight says that, of course, you should have gone out to interview that. But I think the critical point for this case is that at no point were the people exhibiting the kind of wholesale neglect of the case that you see in Regan or that you see in the other due process cases that triggers some sort of pre-indictment delay
So,
concern.
Counselor,
What you
you're
see
out
is
of
them-
time. However, what is your position as to Ortega? Should we hold this in abeyance pending the determination by the Court of Appeals?
No, you shouldn't, because like in Ortega, there's a harmless error issue. It doesn't really matter how the Court of Appeals decision comes down. If there was any error here in admission of the medical examiner's autopsy report, it would be harmless because they affirmatively conceded at trial the manner and the cause of death. There was no dispute at this trial that the defendant was stabbed 70 or 48 times. There was no dispute about the...
But wasn't there a dispute about who did the stabbing, and wasn't, for example, evidence elicited that the defendant was left-handed and the blows were consistent with someone who was left-handed? Does that...
Yeah, and that was opinion testimony from Dr. Smitty, who was subject to full cross-examination. But they don't even really argue about that. What they argue about is the overkill point. That's a point that was made in argument by counsel, and it was a point that came out from their own expert. Our expert never testified about overkill, wasn't allowed to testify about overkill. So this argument that they were somehow prejudiced by the thing that their own expert talked about is just, I think, clearly unfair, especially when you're talking about a point that they affirmatively conceded during the trial. They said, we're not disputing how the murder occurred. We're not disputing what the cause of the murder was.
What you're saying is that we're outside of that issue because Dr. Smitty's testimony reflected his own personal opinions as to what happened, and he was there testifying.
So from the confrontation clause perspective, there's no argument whatsoever with respect to Dr. Smitty. She testified on the stand. She was subject to cross-examination. There might be an argument about whether the medical examiner's report could come in as basis evidence for her opinion, but they don't make that argument. They're talking about the separate argument with respect to the admission of the actual autopsy report itself. Now, this court's decisions and the Court of Appeals decisions, including Ortega, make very clear that the factual statements contained in a medical examiner's autopsy report are not testimonial. And that stands, those precedents stand regardless of what you think about the Second Circuit's decision in Garlick. If there is some remedy for the defendant to have after Ortega is decided or after the Supreme Court says something about medical examiners' autopsy reports under the Confrontation Clause, certainly 440 it remains an available option for them. But there's no reason for this court to delay its decision under settled precedent, especially because the error in this case would have been harmless in any event.
Thank you.
Thank you.
With respect to Your Honor's questions about the delay, based on my adversary's brief, in 2002, they brought clothing, the deceased clothing and stuff to the FBI, and the FBI told them that with the amount of blood loss, that any secondary source would be lost. They did nothing on the case until 2010, when Cyrus Vance was elected district attorney, and they had a conference. They waited 2 years after that to resubmit the evidence to the FBI. So from 2002 to 2012, they did absolutely nothing on this case. They called it a cold case, and they ignored it. And it was only after Cyrus Vance was elected, they started looking at it again. But now we're still up to 2012, and my client wasn't indicted until 2017.
Your client was not incarcerated during that period of time, correct? He was going around living his life.
Yes, Your Honor, and that's an interesting point because the district attorney uses that to say that he wasn't prejudiced and yet argues that because he was going around living his life, he's not entitled to a sentence reduction because despite having spent 20 years showing he's rehabilitated himself, I mean, he wasn't hiding. It's not his fault that the prosecution was doing nothing. So yes, he went on and lived his life, but he was not indicted till almost
But there was no
What's
prejudice.
what's the prejudice? That's right. What my question is, what's the prejudice to him?
Well, the prejudice is, if you look at the evidence against him, entirely circumstantial and incredibly weak. Yes, this trial took weeks, days, thousands of witnesses. They all showed that his sister had a reason to hate her husband, had a reason to want him dead.
But you're saying that flows directly from the delay? What's the prejudice to him from the delay?
From the delay, any possible evidence that would have been established from his clothes or his car, for instance, no blood, gone. And the district attorney's answer to that is he should have preserved it. No, it's not his job to preserve it. They took his clothes, they took his car, they cursory examined it, and then they let it go. Now he can't establish.
Didn't they give that stuff back to him?
Excuse me?
Did they give his property back to him?
It's not clear whether he got it back or not, but the
But
point.
the car was sold. I don't think the state sold the car.
Okay, so they gave it back, but the point being that if you're indicted right away and the police have released your car and you know that the fact that that car has no blood in it, if you stab somebody 48 times, your clothes should be covered in blood, your car should be covered in blood, but you can't prove that negative 20 years later. All you can do is try to argue as they did, well, the police took it and returned it, so there clearly wasn't any evidence in it. But there were witnesses, the building is gone, everything is gone, memories are gone. The people were allowed repeatedly during trial to lead their
Did
witnesses.
he not think that he was a suspect for the murder?
He did, he was a suspect, he knew he
So
was a suspect.
he knew that entire time, right after the event, that he was a suspect. And so you're saying he did nothing to sort of preserve evidence that might show his innocence or not, to help prove that he wasn't guilty?
Well, I guess the question would be then, and we don't know the answer to this, how long was he required to maintain all this evidence? Should he have hired an investigator to go take pictures of the
I'm
scene
just
because
asking,
he might be indicted at some point?
I'm just trying to figure out what you've got on prejudice, that's all.
Right, and what I'm saying
Just the
is-
passage of time, you're saying, is all you need to show.
Right, but what I'm saying is, this is why courts have repeatedly found that a delay as long as this one, you're not even required to show prejudice because memories fade, people disappear. Things that you might have investigated back had you been indicted within a year or two are long gone.
You know, a delay normally inures a benefit to the defense as opposed to the people. Because if you have a delay, as you said, memories fade, you lose witnesses, it's normally the people who are at a disadvantage because of delay.
Well, I don't know how to respond to that, Your Honor, because if we look
I'm just saying in general, that's normally what occurs, but I do understand, you know, your argument in terms of the delay, and I think there was something also that his mother might have been a witness, but she had passed, and so he wasn't able to present her as a witness.
Again, I mean, we've attempted to show what might have been. We can't exactly establish alibi witnesses, but what might have been. That's a delay this long when at least 10 years, absolutely nothing was happening on this case.
Thank you very much.
Thank
Thank you
you.
both. Sanchez v. Walton.
Good afternoon, may it please the court. Anthony DiStefano for defendant appellant Walton. The Court of Appeals has said that for a worker to be covered by the labor law, they must both be hired and permitted to work on a building or structure. In this case, it's undoubtedly true that the plaintiff was hired to work at defendant Walton's building, but plaintiff was not permitted to work in the area where he was ultimately injured. And that is borne out by the fact that he accessed an area that was behind a locked gate. And to do so, the tenant who had hired him climbed over the fence and let the plaintiff in. For that reason, the tenant who did not have permission to open the gate, because only the superintendent of the building had the key, and the plaintiff who followed in were akin to trespassers, which the
I understand the argument, but how is the plaintiff a trespasser? Maybe there's a violation of the lease by the tenant, but certainly he has consent from the tenant to go onto the premises, no?
consent that the tenant did not have the authority to give. He's akin to the plaintiff in Morton, who was hired to work at a particular location, but because his employer had failed to get a permit for that work from the state, he was a trespasser on site. And the Court of Appeals in Morton said that the owner, the state, did not owe a duty to the trespasser. And it would be the same here. Just because the tenant who had no authority to let the plaintiff in gave his consent does not mean that we don't treat him as a trespasser.
So vis-a-vis the plaintiff, the tenant had apparent authority.
The apparent authority to climb over a fence and open a locked gate, I mean, that's not apparent authority.
Well, no,
The
no, but
lock is
counsel,
there
isn't
for a
it
reason.
true that at least that in some instances, the door was open, right? The gate was open. It's not every day. There was one instance where he climbed over. There were other instances, the plaintiff testified, and there was nothing against, no countervailing testimony, that the gate was open, and he walked right in, right?
And that was the actual day of the incident?
Correct.
That the gate was open?
Correct, and it was based on hearsay testimony from the plaintiff that Mike had called the superintendent and gotten the gate open. When Mr. Weissman, who's the property manager, watched the surveillance video with the superintendent, both of them did not know how the plaintiff had gotten into that area.
Gate was open on the day, right? And the tenant says to the plaintiff, go ahead in and do that work. So as between the plaintiff, who's got permission from the tenant with an open door, and the owner, you're saying we should put the onus on the plaintiff?
I'm saying that he does not meet his burden of proof on summary judgment to prove that he had permission to be in that area because it's based on the hearsay from the tenant that he had gained the consent. That's what I'm saying. I'm not saying that that at that point then you throw the plaintiff out.
I'm sorry. It's based upon the hearsay of the tenant when the gate is open?
The hearsay testimony of the plaintiff that the tenant had spoken to the landlord and gotten access to the area.
Does that matter?
That's
The
the
gate was
third
open.
day.
It doesn't matter because the gate was open. On the date of the incident, the gate was, I mean, perhaps I could understand your argument if this was one of the days where Mike had to climb over the fence at the gate. But on this particular day, and this is the third day that he's doing work, right? On this particular day, the gate is open. So how does it, I'm not understanding how it constitutes hearsay when the plaintiff testifies that the gate's open and they walk through.
Because plaintiff testified that he does not know how the gate opened. First of all, he also testifies that Mike
You're
opened
saying
the
that that's his burden to figure out how that gate came to be open?
What I'm saying is that he testified that Mike had already opened it. That was his first statement. That's on page 390 to 91 of the record. He testifies Mike opened it. Then he says that Mike spoke to the superintendent and got it open. So what I'm saying is that that's the hearsay. The testimony that
All right, so you
I
ignore
heard
that
from Mike-
hearsay. You ignore that hearsay, and what you're left with is the door was open and he walked through it.
I'm sorry?
You ignore that hearsay, and what you're left with is the door was open.
Yes, the door was open, but he has no idea how the door got
Does it
open.
matter? He has to know that? He has to launch an investigation to see how it came to be that that door was open?
Because the first 2 days that he comes to the job site, somebody has to climb over and unlock the gate to let him in.
Right, but I thought
By the
that
third day.
that Mike said that, you know, the person who had the key, who I thought there was testimony later on about that the person who had the key failed to open the gate.
They called the super didn't come. I don't know how they opened the door. So Mike's children climbed up and they opened it, page
Right.
251.
So by the way, was there an affidavit submitted from Mike as to exactly what did or did not occur?
No, there wasn't, because Mike would have actually been the one who would have benefited the plaintiff here, not my client. My client, the owner of the building, had the testimony of the superintendent, I'm sorry, from the property manager who watched the surveillance video and said that they had no idea how the plaintiff had gained access to the area because only the superintendent had the key, and the superintendent did not open the door to let the plaintiff in.
Plaintiff was an independent contractor, is that so?
Yes, he was, Your Honor.
He worked for himself.
He did, Your Honor. And for that reason, one of the points that we argue in the brief is that the plaintiff had the ability to make his own choices about the equipment that he used. And although he used the extension ladder on the first couple of days that Mike had provided, on the third day, for whatever reason, the extension ladder was not there, and they chose to, he says Mike forced him to stack 2 A-frame ladders on top of each other. But as an independent contractor, that's not something that anybody can force on you. He had the right to walk away. This is not the ordinary worker in the labor law circumstance that, who has to fear for his job. This is somebody who, as an independent contractor, could have gotten his own equipment, could have done the job
In
safely.
other words, you could have left the job, not got paid? I mean, that's what you're
He
saying?
could have gone to a Home Depot and rented a ladder. I mean, there are so many other things that he could have done, or he could have said, Mike, you had the extension ladder for the first 2 days. I need it for the third day.
That's
I'm
not
not
what
doing
he
this
asked
work
for. He
without
asked
it.
for the extension ladder, as I
Yeah, he
understand.
asked for it.
And they argued, and then he ultimately caved in and climbed up the 2 A-frame ladders. I mean,
He said he
again,
felt pressured to do so.
he felt pressured to do so, but as an independent contractor, it's a completely different situation. I mean, this is akin to the Kerrigan situation where he had the choice to make, and he made a choice that ultimately ended up in his accident.
No, but he's hired by your tenant, right?
Correct, he was hired
So
by the
your so he's hired by your tenant to do this job. Your tenant doesn't give him the 2 ladders. In that situation, like Senatus, I think is the name of the case, it seems to me directly on point that the owner cannot escape liability in that circumstance, regardless of whether he's an independent contractor. You're liable for your tenant's failure to follow the labor law.
Correct, Your Honor. And all I'm saying is that when we look at the totality of the circumstances here, across the 3 arguments that we have in our brief, this is not the ordinary labor law scenario. First, we have a question about permission to be in an area. Second, we have a question about whether this is even an alteration or not. And then third, we have a question about what do you do when you have
The
an
question
independent
about being in
contract.
the area is between you and your tenant. It's not between you and the worker who goes into the open door to do the work that the tenant hires them to do. It has nothing to do with him. It has to do with you and your tenant.
What I'm saying is this is not
You
the
can't put that on the plaintiff.
This is not the ordinary labor law case, is what I'm saying. The Court of Appeals has set limits, and each one of these limits, you would have to expand.
How is this different from Senatus?
This is different from Abatiello and Morton. This is different from Joblon, and this is different from Miro, where the court found questions of fact, the Court of Appeals found questions of fact about the availability of a ladder. That's what I'm saying, Your Honor. Across the board, this is not your ordinary labor law case.
Thank you.
Thank you.
Good afternoon, Your Honors. May it please the Court. My name is Travis Wong for Plaintiff Respondent. I'd like,
As you look at the video of this, and I want to preface this by saying I understand that the defendant is responsible for what Mike Stelly did. It's his tenant, he bears responsibility for that. But as you look at the video of one ladder being placed on top of another ladder, the situation is so pervasive with hazard that doesn't it reach a certain point at which, I mean, if the plaintiff decides to jump from the roof,
understood.
who's responsible for that? I mean, he decides to get up on these ladders, which is so, is he's figuring out, and it's so obviously so hazardous to move as he's walking up those stairs, and then he's putting the second ladder on top of the first ladder. That how, if someone makes a determination, and this isn't, I think there is a point to this. This isn't an employee fearing for his job. Maybe he's fearing about getting paid. I understand that, but this is an independent contractor. He comes in to do the job. He knows it's dangerous, and as he's putting one ladder on top of the other ladder and climbing up, it's no surprise that they fall. It's almost impossible that it shouldn't have fallen. Isn't there in that an issue of fact of sole proximate cause?
Absolutely not, Your Honor. There's no case in the law that says that there's some level of recklessness or condition that puts the onus on plaintiff to provide his own safety devices. Here, there were
Provide his own what?
his own safety devices.
That's not a safety device.
A ladder, any device used to reach a level is a safety device to
Do
protect
we
that
need a
person from a
case to
height.
say that sheer stupidity, that you should not be able to recover from sheer stupidity?
I, yes, I would say so. If there's a very strict burden on all defendants
I mean,
to
let's
provide
put it,
safety devices.
let's put it on no one in their right mind, basically, would get up on that second ladder. I mean, it was just a fall waiting to happen. You couldn't possibly think that you could go up on that second ladder and escape unharmed.
There's no burden on a plaintiff to show
Common sense.
common sense,
I
exactly,
mean,
thank you.
he is an independent
It-
contractor. I mean, he
what's
comes
the
into a
difference
job. I mean, he
between
could
an-
just,
Sorry.
any danger he decides to undertake, he's not
There's no
responsible
difference
for?
truly between an independent contractor and an employee in this situation. This is his livelihood. He's there to get paid. He's there to make money to live his life.
Did he ask for an extension ladder?
He asked for the
And what
ladder.
happened when he was asked?
When he was asked for the ladder, he was told it was not available. He was told to use the two ladders. Those
After
were
he
the
had it
only-
on the 2 prior days.
He did have it on 2 prior days, but it was not available on the day of the accident.
So he knew that that what he was doing was not the way to do it. And nevertheless, he proceeded.
There is testimony. He said he knew that it was dangerous. There was a risk he was taking. This is his livelihood, though. He was pressured to do this to pursue his livelihood, to complete the job that he was given.
He's also pressured to protect body and limb.
So I would just ask that, does a plaintiff have a burden on them to protect themselves in these situations? Do they have a burden to walk away from their job sites? Under DeRose, there's no burden on plaintiff to seek out appropriate devices to
I
perform
mean, if
their
someone
work.
tells you to jump off of a roof, you don't jump.
But this isn't jumping off a roof. This is something, I wouldn't say it's
I'm not
right.
so far as you look at the video that it's so different.
So
When you see
I
how
would say then
one
that
ladder is perched upon a second ladder, how could it not fall?
well, I would say then that you're asking all plaintiffs to have a certain level of common sense, all construction workers to have some ambiguous level of judgment in the devices they use in the
I
situation.
mean, this is an ambiguous level of judgment. This is just not to jump off the roof.
I would disagree with you. I think that when you're in a position where you need to do a job to protect your livelihood, where you're pressured by someone who is paying you, people make bad choices. People do
Let me
things.
ask you, counsel, how do you deal with your adversary's argument that he's a trespasser?
I would say under Morton, Morton is about creating a nexus. There was a nexus created here between the plaintiff and the defendant owner by the
Are you,
lease agreement.
do you disagree that the record raises an issue of fact as to whether or not he was a trespasser?
I don't think it matters whether or not he was a trespasser. I think the nexus is.
Oh, you're saying if he was a it wouldn't, if he
No,
was.
sorry, not a trespasser.
I don't think you want to say that,
I'll take
right?
that back. I think that the nexus was created, and under Sanitas, that nexus is not broken by permission. This is a question of permission, whether or not the tenant had permission to let him into that area. Under Sanitas, permission does not break that nexus. That nexus stands. It is solely based on that lease agreement. Plaintiff was installing these 2 refrigeration units.
So it's your position, he doesn't have to call up the owner and say, hey, does your tenant who hired me, am I allowed to
Absolutely.
do the, right?
Yeah, how would the
That's
plaintiff?
between the two.
Absolutely.
Okay.
Thank you.
Thank you, Your Honors.
Unless the court has any additional questions for me, I would cede the remainder of my time.
Thank you very much.
Thank you.
Adriana K. versus Grigor K.
Good afternoon. May it please the court. Andrew Coyle for petitioner respondent Adriana Kubianek. In July 2018, the appellant knowingly fled the United States while 3 domestic relations cases were pending, a custody case, a child support case, and a matrimonial case.
Are you suggesting that he wasn't involved after he left the country? And it's my understanding that he had to leave because there was an issue with the visa. Is that correct? Am I wrong about that?
The answer is I don't really know his visa circumstances.
Well,
I know that
didn't the wife say that he couldn't be on the visa because she had some particular kind of visa and they were getting a divorce
so the documentary evidence is that she told him that, and he
left, right?
He left, but there was
Hold on.
Yeah.
And did he, from Poland, maybe Switzerland while he was skiing, did he engage in the proceedings in any fashion?
The answer is only when it suits his purposes. So with respect to this violation petition, he defaulted. He missed 5 separate court appearances, including a trial scheduled before a support magistrate, and then he uses his absence from the jurisdiction as an excuse not to pay child support. I mean, he sent a letter in 2018 to the family court saying it would be unconscionable for him to pay child support because he lives in Poland. In 2019, he filed a motion to vacate the child support order, which was issued on default, and he claimed that his absence from the United States was his reasonable excuse for not appearing. He could have appeared by phone. He could have come voluntarily to the United States. There was nothing preventing him from participating. He's just using it as an excuse. In 2020, he sent a letter to the court saying that the violation petition should be dismissed because he's not in the United States. Most recently, on January 6, 2022, his counsel said he's in Poland. As a result, he's unable to make payments. He's continuously used this as an excuse not to pay child support. We had a court appearance today in family court. He's still in Poland. He's still represented by the counsel.
May I ask you, has the mom the mom has the child now, correct? Okay.
Correct. Mr. Kubienik is $112,600 in arrears. He has not paid 1 cent through support collection. So I specifically wanted to use my time to address a case that was raised by the respondent in the reply brief, Hillary C. versus Michael K. It's a 2022 case that did not apply the fugitive disentitlement doctrine. That case is completely in opposite to this case. There's a clear nexus between his absence from the jurisdiction and his failure to pay child support. As I went through, he's used it as an excuse at every step. More importantly, his absence from the jurisdiction has frustrated the collection. There's a $35,000 money judgment. Not 1 cent has been collected through the money judgment. And there's been a warrant for his arrest for 14 months, I believe. He has not been apprehended. I was ordered today to serve Interpol, the FBI, and the Polish embassy by Judge Brown in the family court to have him arrested in Poland and extradited. So I don't think he has any right to pursue this appeal. And for the other reasons set forth in my brief, including that he defaulted in the trial court and missed 5 separate court appearances, I don't believe that his inability to pay is before the family court. So that's why they didn't address it. He did receive effective assistance of counsel. He was appointed counsel, I believe, in about February 2020. He didn't contact that counsel until February 2021. There's a whole year where he didn't even bother to contact his counsel.
Thank you, counsel. We have your brief.
All right, thank you.
Thank you. Take care. OSI LLC versus New York State Division of Housing.
Good afternoon, may it please the court. I'm Robert Embarrass. I'm of counsel to Mark Palomino, who's the counsel for the respondent, New York State Division of Housing and Community Renewal. I'm appearing here today for one purpose, which is to point out a significant misstatement of fact in the appellant's reply brief. The appellant in its reply brief, the appellant in their reply brief state that there are the 2 apartments in question are both occupied by rent-paying tenants. That may be the case today, but that's not in the record. The record pertains to 2019 when the appellants filed their applications. And at that point, the apartment owned by appellant OSI was vacant, and that is,
How would a landlord correct the correct the registration? Is there a procedure which the landlord could have used which would have satisfied DHCR?
DHCR's position is that there needs to be an individual rent-paying tenant in place who would have the incentive to contest.
So let's say there is an individual rent-paying tenant. What do you do then?
The owner would file the application. Here in this,
Is that, so you say one apartment was vacant. What about the other apartment?
the other apartment was occupied, and by the way, the vacant apartment, that's at page 205 of the record.
So what about the apartment that wasn't vacant? Why
That's
didn't-
at page
why didn't it work?
269 of the record. That was occupied by a corporate tenant. And as we point out in our brief, a corporate tenant has much less incentive to contest its rent than an individual tenant, because presumably it's writing
So you
off.
mean if an apartment is occupied by a corporate tenant, there's no way to correct the registration?
I believe that would be in our position, Your Honor.
And that would be based on what?
Pardon?
That's based on what?
That's based, the reasons are laid out in our brief, Your Honor.
Okay,
Thank you.
thank you. Pause versus 565 Equities, Inc. This matter, Justice Friedman is recused.
Good afternoon, Your Honors. May it please the Court. My name is Matt Geyer. I represent the plaintiff appellant. Your Honors, the defense verdict finding no negligence was the result of multiple errors by the trial court during the trial. Most notably and most importantly was the jury charge on the issue of negligence. As the Court's aware, what's claimed here by the plaintiff is she was walking in front of the defendant's building, and chunks of frozen snow and ice came tumbling down, hit her in the head, caused traumatic brain injury. The defendants claim it fell from a tree.
But I have an expert. You have an expert, right?
I do.
Says it fell from a tree, right?
Their expert said it fell from the tree.
I'm sorry, the expert, we have an expert in the record who says that it fell from a tree.
That's correct, and we have an expert who says it did not.
Right.
But the point on the charge is that there is no PJI charge on point with respect to this particular type of premises liability, to wit, accumulation of snow and ice on the exterior of a building. Therefore, I requested in advance of the trial and during the charge conference a specific charge from this court's very on-point case called Taylor versus Bankers Trust, which specifically set forth the standard of care for that specific situation, the duty incumbent upon owners of a building when there's ice and snow. I requested that charge because we're entitled to a specific charge when there is a specific duty.
But counsel, wouldn't it be fair to say that the court sufficiently charged the jury to convey to the jury that defendant could be responsible for the accumulation of snow and ice on its facade if there was actual or constructive notice? Wasn't that conveyed?
No,
And
that
isn't
really,
sufficient?
what the specific duty incumbent upon the owner was absolutely not conveyed, and let me explain why. The charge came from Taylor. The essence of, I'll read it to you to make it quick, okay?
I have it in front of me.
Okay, good.
I think we all do. So
All
that
right,
was,
so I don't need to read it, but the operative part is take reasonable steps to ensure that no object will fall to the street, or if need be, to rope off the sidewalk or in some other way warn pedestrians, okay? That does not appear anywhere in the court's charge. Now, here's the interesting part. This jury, by the way, struggled with this issue. 5 readbacks on the negligence charge. How is a jury to know, and this is a rhetorical question, of course, but how is a jury to know that a private landlord of a private building has even the right to cordon off a public sidewalk, much less the obligation to do so, if the court does not charge that duty? That was absolutely required of the court's charge. It is no different than when this court reversed in Montañez for failing to charge that there is a duty to ride on the right side of the street, which frankly everybody knows, okay? And in the Downs case from the Court of Appeals, where they said, separate from all the general charges on the reasonable prudent driver, an absolute duty not to back up unless you can do it safely. That required a new trial. This is the same type of specific duty. A jury had the right, should have known, the plaintiff had the right for the jury to hear that they had the obligation to cordon it off if they couldn't otherwise make it safe and prevent snow from falling down. And that was prejudicial error, and we know that because they came back and asked 5 times for readbacks. They wanted it in paper and hard copy. They wanted it read slowly and with breaks and pauses. They could sit there and listen to it as intently as is humanly possible. They would never have heard the words that they needed to hear, which is the obligation to rope off the sidewalk.
So, counsel, could you address the issue as to the preclusion of cross-examination?
You mean on the deposition testimony?
Yes.
Yeah, sure. So on the first witness, plaintiff attempts to read. The defendant was deposed via Mr. Lucid. He was their employee at the time he was deposed. He's the superintendent. That's the defendant's deposition. And there's also Mr. Dizon, who is no longer employed. He was the doorman. We have these depositions. He goes to cross-examine the building manager, he called him as his witness, about these employees that he was supervising. Judge says, no, you can't do that. Why not? An in limine motion wasn't made. But Judge, an in limine motion doesn't need to be made for deposition testimony.
But is that reversible error? Maybe it's error, but is it reversible error?
Sure, it's reversible.
Why?
It's error. They've conceded it's error.
Why? Okay, but why is it reversible error in this circumstance?
Okay, because the purpose of calling the defendant to the stand is you establish your case through the defendant and hopefully be able to use deposition testimony of the people that he is actually supervising to get inconsistencies and contradictions and show to the jury the holes in their case.
Specifically in this case, why was it prejudicial? Yes, of course, you cross-examine someone, but why was it so prejudicial in this case?
Mr. Lucid testified that the only time they had ever used cordoning off was for windows. Mr. Hess, the manager, said, we've done it in the past for snow and ice. Mr. Dizon testified, Mr. Hess testified, I would like to know if there were prior instances of snow and ice falling off. Mr. Dizon testified there were.
For constructive notice purposes or notice purposes?
Yes, and how they react to it.
You weren't able to show constructive notice in the way that you wanted to by not being able to cross-examine him about whether they had done this sort of stuff before.
That is correct, Judge, and we were unable to actually get the kind of live, I mean, the testimony of Mr. Hess went nowhere because there was nothing to cross-examine him with. I mean, this is what the case is built on, these depositions, and we had nothing.
But did you later get to put in that testimony?
When they were, yeah, after Mr. Hess is off, after plaintiff's expert's off.
When the judge wouldn't let you recall the witnesses?
Oh, no, that wasn't, no. No, and we couldn't. And we also weren't able, there was video in evidence, by the way, this is just the other point, that no conditions, no subject to redactions, videos and evidence, but the judge doesn't let you show what you want to show, even though it's a video that's in evidence.
Thank you.
Thank you.
Seabriggs Johnson for the defendants.
So counsel, can you address the issue with respect to the EBT transcripts? I mean, what your adversary is arguing, in essence, is that plaintiff, at the appropriate time, when Hess is on the stand, is not able to bring up inconsistencies between what Hess is saying and what his employees are saying, which are important with respect to credibility, what the jury is going to hear and ultimately decide.
Sure, I think there's 2 ways to address that. The first is that the jury asked for a readback of that testimony, right? And when they asked for a readback of that testimony, there was no note regarding confusion, regarding some kind of misunderstanding of that testimony, regarding anything else.
Well, the testimony was unchallenged, right?
Yes, the testimony was unchallenged.
So, of course, I mean, if it's unchallenged, what kind of confusion could you have?
Right,
but let me ask you this. Did you contest notice?
Oh, at trial?
Yeah.
Oh, of course we did.
Okay, so an issue, and in fact, you stipulated to permit cross-examination of the witnesses with this deposition testimony?
Yes, we did, and we both read the portions that we felt relevant to our case.
No. You stipulated that cross-examination could occur based on this testimony.
Oh, yes, we did that
And the
too.
judge nevertheless said no.
The judge never said no, yes.
So you concede that's an error. The only issue is, was it prejudicial enough to require a new trial?
Precisely, and I think, what my adversary is trying to say about Mr. Dizon and Mr. Lucid's testimony about prior instances of falling ice, remember, when you have a falling ice case or any kind of dangerous condition, it's notice of the specific condition of the specific location where it happened. And Mr. Dizon and Mr. Lucid unequivocally testified repeatedly that there was no prior instances of prior ice chunks falling from the building, that there was melting water and little snow pieces falling, but never prior ice chunks.
Okay,
Well, the
but
distinction is there is something coming from the facade, correct? I mean, that's the distinction, that it wasn't ice, but it was melting water?
That's what they said. They
or a
said,
giant chunk of snow, that should distinguish it as a pound of snow?
I'm saying, but the jury was presented with this evidence, and they were read both
But
sides
not
of the
through-
story.
But not through Hess's testimony. I think that's the point, that that Hess's testimony essentially went unchallenged on these issues because plaintiff was not able to bring up the inconsistencies with the employee's testimony.
I guess I see.
Or I'd say alleged inconsistencies.
Alleged inconsistencies, right? We're talking about minor inconsistencies here. We're talking about Hess was.
But this is a he said, she said case. Minor inconsistencies are important, no?
Perhaps they are. But I think in this case, on balance, the evidence from those two witnesses was pretty strong in terms of the no prior notice of the type of condition that happened in plaintiff's accident. And if you
What about the video, right? There was a
Right,
ruling
so-
that the
so the
video
video-
was permitted again.
right, so
So the not showing a video that was in evidence,
right, but the plaintiff.
error.
It was error, but the plaintiff already.
Let me just ask you.
Oh, I'm
'cause
sorry.
So now we have one error that you concede, two errors that you concede, and why wasn't the second error?
I don't concede that was error at all. I think
Oh.
that the jury already got.
Wait, so you thought the judge incorrectly allowed the video into evidence?
No, I'm saying his argument is that the preclusion of Exhibit 2B was reversible error. My argument is that it was proper to keep that video out of evidence.
Because it showed subsequent repairs?
Because the jury was already showed subsequent.
Hadn't she already moved the evidence? Hadn't she already ruled that it could come into evidence?
Yes, but the jury was already presented with evidence of the subsequent remedial measures when Mr. Berry was
So
examined.
why not show the video if it's in evidence?
I can't explain why she didn't
So
do that.
why would that not be error?
Because it's already duplicative of subsequent remedial measures that are already in
You're
evidence.
saying it's error, but not prejudicial error.
Exactly, because if we're going to keep putting, over and over and over again, my client putting up caution tapes and cones, the jury is going to get the inference that, oh, you know what? This is actually evidence of negligence. And that goes back to point one, which is that the charge really on balance was in the spirit of Taylor and Klepper and what plaintiff wanted in the first place. If we look at the jury charge, and I counted 7 times, the court told the jury that a dangerous amount of snow and ice was accumulated on the facade of the building at least 7 times, and that the jury could find that the defendant's negligence, if they had sufficient time to identify and correct or remedy that condition, to provide safeguards and warnings thereof, to have corrected the condition or taken other suitable precautions at least 7 times. That's 1590 to 1593 in the record. And if we charge the jury under Taylor and Klepper, okay, the problem with what Mr. Gare wanted there with the jury charge.
Let's put the jury's charge aside, right?
Sure.
Because she charged the PJI.
Right.
Let's talk about the 2 errors that you concede.
Well, I didn't concede the video as error.
Okay.
Yeah.
But
Oh, it's
in
not
evidence.
harmless. It's not harmless error. Excuse me.
Right. It's in evidence and it wasn't shown to the jury.
Right, right.
That's an error. You agree with that, right?
Sure.
Okay. But you're saying those 2 errors together weren't prejudicial enough to require a new trial.
No, and I think my problem with video 2B, Your Honor, is The jury's presented twice with evidence of subsequent remedial measures through the direct examination of Mr. Berry, and then they're shown the video in the presence of the jury.
But there could have been a limiting
redacted.
instruction.
Right.
Or you could have redacted that
Yeah,
portion
yeah,
that showed the cones.
Sure, and I'm stuck with the appendix, right? But if we think about this, if the jury's shown this evidence time and time and time again about cordoning off and putting caution tape up, they're going to say, especially with plaintiff's email, oh, that's negligence. That's negligence in this case. And remember, 2B, Your Honor, is another side of the building. It's not where the entrance is.
But isn't it basic law, I guess, or evidence that if something is in evidence and the video is in evidence, that the jury has a right to see everything that's in evidence? I mean, it's been a while since I was in law school, but I thought that was like, we learned that almost like the first day.
Evidence for me was second year, but that's basically my only response to that. I would just say, I know I've
You're
learned
right,
my time.
it was
Second year, right?
It was second year, yeah.
I thought
I told you it was a long time ago.
I thought I had a day in that class. I got to
It all kind of meshed together.
Yeah,
It's like,
it doesn't matter.
yeah.
It's like a monstrosity.
Like a
but,
bad dream.
the video is the other side of the building, okay? And the jury has evidence of subsequent remedial measures. If we keep bludgeoning over the head with that, it's an automatic plaintiff's verdict in that situation. And so I think on balance, the PJI is the guidepost. It's 290. They got the charge they wanted, and evidence went both ways here. So let's not pretend that there wasn't a fair trial here. Every judge makes errors in a trial, right? There's so much going on. Nancy Bannon's a respected judge. She did a good job. That's why I think the judgment should be affirmed. Thank you.
Yeah.
All right. First of all, Mr. Dizon testified at his deposition that he's seen snow and ice falling to the facade and the ACs in the past, 1167 of the record. There were times when he told people to walk away from the building and physically waved his arms and shoo them away from falling snow and ice, 1167 to 68. And then there's his written statement that was read into the record, which is part of it, most of it, I think, during the trial record, where I know ice melting, falling from ACs at units of 565 West End Avenue. Clearly, there was important notice information there. Number two, the video. They never even saw the subsequent remedial measures. Plaintiff's expert, Mr. Berry, testified about it. He was allowed to testify about it because it was in evidence, because it was in the video. But they never get to see any of that. The thing that was played 12 times was the actual incident itself. And when plaintiff's counsel wanted to show them the video, it was two segments. They got to show one, the kicking of the block of ice across the road, the sidewalk that could never have fallen from a tree branch. And then the other one was the chunk of ice actually falling from the building, landing on the sidewalk, and the guy pointing at it. And this is after defense counsel elicited from Mr. Hess. You don't see anybody pointing at the building after that. And that was redirect. And the judge ruled it was improper redirect after they opened the door. In any event, it was totally relevant because 11 minutes later, it's showing the same condition going on. And look, just with respect to the charge, I can't give this one up, okay? Because here's why. Not only did I ask for a charge in accordance, I get you, in accordance with the law, okay? Then the email that they published to the jury that basically states what's in Taylor, okay? Then the jury comes back and asks the question, is this valid and true? And the judge says, well, I give the law. And we say, yeah, okay, that's fine, you give the law, just please don't say accurate or inaccurate. The judge says, I'm just gonna say it's the law. They come back in, the judge reads the question, is this statement of responsibility valid and true? And the court says, the short answer is no. The court
She said
charged
the
the
short
opposite of the
answer
law.
is no, but then she did go on to give somewhat of a long answer and say, I instructed you throughout the trial that you're not to listen to anyone else in regard to the law.
Yeah, but those 5 words, the last one, no, it's the opposite of the law. It's an erroneous instruction. She charged the jury the opposite of what this court ruled in Taylor. To me, that's as great an error as you could possibly get, and it couldn't be more prejudicial.
Thank you. Thank you, Bill. Thank you. You too. People v. Curtis Hill. Whenever you're ready.
The Legal Aid Society by Lawrence Houseman for Curtis Hill. Good afternoon, Your Honors. This afternoon, I'd like to argue both aspects of our suppression argument. First, that the hearing court erred in crediting Officer Cox's testimony, and second, that even if you do credit Officer Cox's testimony, the police still do not possess reasonable suspicion.
So we have an anonymous phone call, an anonymous tip, right?
Yes,
And then the individual gives a generic description of the individual who allegedly had a gun.
that's right.
And also, we have a partial plate of the vehicle.
There is a partial plate of a vehicle, although Mr. Hill is not in the vehicle.
Okay, but we have the information imparted to law enforcement in the tip is person with a gun, man with a gun, generic description of that man,
Black male, yes.
black male, a partial plate, and a description of the vehicle. Was it a black Acura or something like that?
Yes, I think the Acura was adequately described, though there was no connection between my client and the vehicle.
Now, the police encounter a individual who fits that generic description near the vehicle with that partial plate, right?
And yes,
How far is he from the vehicle?
they say he's about 3 to 5 feet, and this is 8 o'clock in the evening on November in what's called a busy area. There's other people on the sidewalk, and the quote-unquote descriptive match that the people are relying on is a description black male, and that's just not in that neighborhood or really anywhere a basis to distinguish him from anyone else around in the area.
I thought there was no one else fitting that generic description,
Not within-
no one else fitting that generic description near that vehicle.
Within 3 to 5 feet, but there were other people on the sidewalk. And another important point.
Didn't the defendant allegedly also make a statement regarding a gun being called in? I mean, how does that play into it?
Well, Your Honor, a couple things in response.
I know he
to that.
says that's preposterous and he would have never said
Right.
something like that. as a
And so
black
I'll
man.
get to the credibility issues in a second, but first of all, I think the police should have never been approaching someone on the description black male. And another important point about this not only
What
was
does
an
the record
anonymous
show-
tip.
What does the record show as to the other people around? Because the description of the vehicle is that you get 4 digits of the license plate, right?
Yeah, I have no
7066.
quarrel with the notion that the vehicle was specifically described. There's just no connection based on the information the police have between our client and the vehicle, given that there were other people on the sidewalk, other people
Well, Officer
around,
Cox testifies that he's 3 to 5 feet away from the vehicle.
and not doing anything to connect himself with it.
What is the testimony as to the other people on the street?
Just that
Who
there are
else
oth-
was there?
Just
Who
that
else
there are other people on the sidewalk, other people around, and that it's a busy area.
How far away?
There's no specific testimony about how far away,
Was
other
there any
than
testimony that he was the only black male in the vicinity?
not in the sidewalk, close to the car. He was the only black male
And the
close to
tip
the
here
car.
says that there's a black male with a gun inside the car.
That's correct, Your Honor.
Inside a black Acura with a license plate ending 7066.
I have.
Was there actual testimony as to the proximity of the defendant to the vehicle?
3
Did
to
he
5
say he was
3 to
near,
5
or did he say he was standing near the Acura, or did he actually say, as you said, it was 3 to 5 feet?
3 to 5 feet away.
Was the
And
testimony?
another important point, though, Your Honor, is that there's no time identified with when the hearsay. So the 911 caller says that my brother told me about this man in a car with a gun. There's no time provided as to when those observations of the man with the gun occurred. So the fact that my client was standing near the vehicle, we don't know when the observation occurred.
What's the time of the 911 call?
The 911 call happens at, well, we actually know from records in the case that the 911 call happens at 7:30. Although the officer responds, the officer testifies.
And when did the police arrive at the car?
I mean, they testified that it was around 8 o'clock, although they also testified that it was within 2 to 3 minutes of the call. So there's a little bit of a confusion as to that point. But even if they responded immediately to the 911 call, the problem is that we don't know when the 911 caller got that information from her brother. So we don't know when the actual time occurred when a man with a gun was observed in the car. And so the fact that our client was near a car but there were also other people out on the street on 8 o'clock in a crowded area, just doesn't connect him to the car.
In terms of the police approach to the defendant, what we're talking about is whether there was a common law right to inquire, right?
Right.
We're not talking about reasonable suspicion, which clearly they did not have reasonable suspicion based upon this anonymous phone call.
Right. And I think that's right, Your Honor. And I think that's an important point, I think, that we are relying heavily on, is that the quote-unquote description, black man, does not provide you with founded suspicion. Being out on a side...
Counsel, in order to justify what happened here and to reach the level of reasonable suspicion, one had to believe the officer's statement that the defendant refused to remove his hands from his pockets and that he made the statement tantamount to someone said that I had a gun, right?
That's right, Your Honor. You would have to credit those statements. And I had wanted to start and talk a little bit about Officer Cox's credibility, because that is one of our points. And I'd like to make several points about that. First of all, it's not just, because he said that he responded to a specific clothing description.
Well, he said that the radio run described the man wearing a black hoodie.
Right. Now, ultimately, that was proven not to be true. But not only did Officer Cox cling to that, untrue statement, but he said that he specifically remembered the clothing description being part of the radio run. And he said that as he approached the vehicle, he saw near the vehicle Mr. Hill, who he recognized from the description. But of course, since there was no clothing description, it was simply untrue that he recognized Mr. Hill. Being a black man is not a basis to recognize someone. And so that's just like, evidence that was manifestly untrue. And when he was confronted with evidence that there was no statement, first he said, they said, did you write it down on the data sheet? He said, well, just because it wasn't written down doesn't mean it wasn't said. Then they played the radio run, and he said, well, just because it's not on the radio run, maybe it was on the 911. And then when they played the 911 tape, he said, oh, well, he said, well, I guess it was based on my observation. Now, of course, a police officer knows the difference between an observation and a description.
But
So
this was before the hearing court. And so the hearing court assesses credibility. And so are they not in a better position to assess the credibility of Officer Cox in terms of how he appeared on the stand, how he answered the questions, how he dealt with the inconsistencies?
Absolutely, there's a standard of deference here, but there's also, that deference is overcome when there's a pattern of untrue testimony. And the way in which the officer said that he specifically remembered a clothing description when there wasn't one, that he recognized Mr. Hill based on a clothing description, that he said that Mr. Hill, that the description said that the person with the gun was standing next to the Acura, when that wasn't actually the description. The fact that he said that the knife he tested flicked open when at the suppression hearing, even though he stood up and took his coat off and tried as hard as he couldn't get the knife to open.
But he said that the gravity knife did open at the scene.
Right, but is that credible when at the suppression hearing he's unable to get it to open? He also said that it was dusk, close to nighttime, repeatedly, even though it was over 3 hours after sunset. Also, not credible.
I was just going to say, but wasn't there testimony that the area was well lit?
Right, and so the point about his testimony about it being dusk or close to dusk when it was 3 hours after sunset is that this is an officer who's trying to make his case better than it is. It's part of a pattern of testimony here. And again, like, why is it really plausible that Mr. Hill said, did somebody call about a gun when he didn't even have a gun on him? I mean, this is just a pattern of testimony that was incredible, and so that's why...
Yet there are other portions of it, the Acura, the partial license plate, the color of the Acura, conceded he was a few feet away from it, that was accurate.
Right,
So
but
can we look at it as a whole, and could the trial judge look at it as a whole, or the suppression judge, and then make credibility determinations?
I would just say, Your Honor, the fact that there were some things that were inescapably true, the fact that someone made a 911 call about a black Acura and there was a black Acura there, the fact that there were some things
Not
were
just
true
a black Acura.
Right, I'm not contesting that the Acura matched the description. What I'm saying is that there were key repeated aspects of this officer's testimony that were proven to be untrue and that were
Incidentally,
not
was
just
the Acura,
mistakes.
did the Acura belong to him?
After their arrest, they established that it did, yes.
He had the
They
key
certainly didn't
fob.
know that.
He had the key fob for the car,
That
right?
certainly wasn't discovered until after what we're saying was the unlawful conduct.
Thank you. You have time on rebuttal.
Thank you, Your Honor.
Good afternoon, Your Honors, and may it please the Court. Juliana Susu for the people. The defendant's motion to suppress was properly denied. To start, the lower court was correct to credit the officer's testimony as to his encounter with the defendant. Based on that credible testimony and looking at the encounter under the totality of the circumstances, the officers had reasonable suspicion under Level 3 of DeBoer, justifying the protective pat-down of his hoodie pocket leading to the—
At what point?
I'm sorry?
At what point?
They had reasonable suspicion after the defendant refused repeatedly to show his hands when instructed to do so. The nature of the way—
That's it? You're not relying on the alleged statement that the defendant made, that you're here about a gun?
Yes, I'm relying on everything under the totality of the circumstances.
We have enough to even approach the defendant?
Yes, they did. The radio run description referencing a gun, as well as the officer's quick response to the scene and the consistencies in the officer's observations and—
The only consistency was a black Acura with a matching plate, right? And there was a black male. But the black male, according to the call, was in the car. This black male was not in the car. How was he connected to the car? Or in other words, if the police show up, is any black male that's in the vicinity now subject to this?
So it's entirely possible, and the officer did testify to this, that the individual could have stepped outside of the car during that 2 to 3 minutes between the radio run and when they
Of course,
arrived.
we could suppose anything.
Yes, but the officer's testimony that there was other people on the sidewalk is true, but the defendant was the only individual within 3 to 5 feet of the vehicle.
So what?
They at least had a reason to approach defendant and investigate.
Because he's a black male, right?
Not
That's
specifically.
enough? He's a black male and he's near the black Acura, so therefore he matches the description and therefore we can approach? The officer can approach? How many black males do you think would be on West 154th Street and 8th Avenue?
I cannot say, Your Honor, but
Well, did the officer say?
the officer did not say. But the officer at least had a reason to approach defendant and investigate further. Defendant's unprompted statement referencing a gun, as well as his repeated—
Well, if you credit that, right, and which apparently defense counsel is maybe with basis saying that the credibility of the officer is suspect.
The credibility as to that statement specifically should be credited because it's entirely—
As opposed to his statement about the description with the hoodie?
So initially, he did testify that the description given on the radio run was a black male wearing a black hoodie, standing near the black Acura, where in actuality, the radio run did not give a clothing description, and it only stated a black male, generic black male, inside the car.
As to the black hoodie, the officer did acknowledge during his testimony after rehearing the radio run and the 911 call that he misremembered that very specific fact.
Saying that he acknowledged that
misremembered.
is
He
putting it very
misremembered.
nicely.
I'm sorry.
My apologies. I'm saying that he misremembered once he's confronted with irrefutable evidence is putting it mildly.
It was prior to that he was fairly emphatic that this was that the radio run said a black male with a black hoodie. And again, it wasn't until they actually played the 911, the radio run, that he actually said, oh, excuse me, there was no description of a black hoodie.
But it shouldn't lead this court to believe that the officer's testimony was manifestly untrue, which is the standard.
But the question becomes then, we have the inaccuracy or his misremembering the black hoodie. Then we have the fact that he misremembered that the radio run said that the black male was in the vehicle as opposed to outside the vehicle. So we have those issues of credibility. And then we're asked to believe that once the officer approaches the defendant immediately says, without any prompting whatsoever, is this about somebody calling about a man with a gun?
And that's entirely possible.
And if I could add to that, we're supposed to believe that the officer who cannot flick that knife open through the use of centrifugal force and get it to lock in place at the hearing was able to do that at the scene. And without a doubt, he had to have said that in order to have probable cause, correct?
So I just want to reiterate, explain, the knife did partially open at the suppression hearing.
That's not a gravity knife. A gravity knife, the definition back then, if I remember, was that the blade opens and locks in place through the use of centrifugal force.
Yes, but there could be reason as to why the knife did not fully open. It was taped and placed in an evidence bag for the span of 2 years between the time of the crime and the suppression hearing. It's understandable that the knife could have become stiff, making it difficult using just the flick test to open it. Based on the circumstance, I see
Well, let
my
me
time is
ask you,
running
if
out.
that's the case, then it's no longer a gravity knife, right, at that point? If it doesn't open through the use of centrifugal force, it's not a gravity knife.
But at the time of the encounter, it did open with using
If you believe the officer.
Yes, correct, Your Honor. Based on the circumstances, the officer's conduct with the defendant was proper and reasonable. If there are no further questions.
Let me ask you another question. At the point that the officer found the knife, did he provide any testimony as to what led him to believe that it was a gravity knife before he flicked it open?
Not so much detail. He said that, if I'm remembering correctly, that it resembled what could have been, don't quote me on that, please, what could have been a gravity knife. Using the flick test to open it, that's what determined that it was a gravity knife at that point.
And using the flick test in your position, is that permissible once he finds a knife that he may or may not know what it is?
At least to determine that it is a gravity knife. If there are no further questions, we ask that you affirm. Thank you.
Thank you.
Your Honors, just a few quick points. I think I've covered, and I think your questions have covered a number of the bases for why we significantly question the credibility of Officer Koch, notwithstanding the findings made below.
But you would concede that once Officer Cox, right, approaches the defendant makes a statement concerning, did somebody call, or is this about somebody calling about a gun, what have you, and then the defendant not removing his hands from his pockets as directed to do so, and then the officer, patting him down and finding the gravity knife, that would be sufficient, right?
Well, let me be clear, Your Honor. Even if we credit the notion that he made that statement, let's assume for a second that that's true, which we certainly contest that. I still don't think you get to reasonable suspicion because there's no connection between him and the car other than mere proximity, and there's lots of other people on the street, and we don't know when the knife was
They're not
possessed.
within 2 to 5 feet, 3 to 5 feet of the black Acura.
That's true, but since we don't know when the knife was possessed, the caller doesn't say when the knife was possessed. Being near a car,
You don't know when the gun was possessed.
excuse me, when the gun was possessed. Since we don't know when that happened, the fact that he's near, we're all near cars often, and I just think that's without any connection to the car.
Did you state that the record showed that was there a sprint or something, that the 911, or the actual 911 call came in at 7:30, and then the radio run was at 8?
No, I think in actuality, the sprint call and the radio run were probably both around 7:30, but the officer, so the officers approximated that this all happened at 8 o'clock, and I don't think that's a significant discrepancy that we're relying on. So I would acknowledge that the radio run happened soon after the 911, but what I want to point out is that the 911 caller...
So when the officer gets the radio run that there's a black man with a gun sitting in the car, which has a license plate, which in part is 7066, and when the police officer pulls up near the car, he sees a black male standing 3 to 5 feet away from the car, and that person has his hand in the pocket. What is it that the police officer would appropriately be allowed to do at that point?
Not approach our client, Your Honor. He could approach the car and see what's going on with the car, but I don't think he certainly doesn't have a founded suspicion, which is a level 2. I don't even think he has a level 1.
He's not allowed to say anything to an individual standing 3 to 5 feet in distance from that car?
Not on a busy sidewalk at 8 o'clock in the evening in a busy neighborhood. If this were at
Say
3 in
busy.
the morning,
Is there testimony as to just how many people are on that sidewalk and where they are located vis-à-vis the car?
only that they're not right near the car, but that there are other people around.
And who had
Given,
the
again,
burden, and who had the burden to elicit, if this is testimony which you say undermines the people's position, who would have the burden to elicit that testimony at the hearing?
well, I think that people have the, certainly as part of they have a burden of going forward.
Burden of going forward, right?
I don't think they meet their burden of going forward when they approach someone based on the description black man, when they acknowledge that there's other people around and that it's a busy neighborhood. It's a busy, not only a busy neighborhood, it's a busy part of a busy neighborhood. I don't think they meet their burden of establishing certainly a common law right to inquire, founded suspicion that criminality is afoot when you're a black man standing near a car that conceitedly matches a description. I just think on crowded streets, we're often standing near cars and just having a specific race and gender.
There's no testimony of anyone else being something like 3 to 5 feet distant from the car.
There's testimony that there's no one else that close, but that there's other people on the sidewalk and other people around, and it's a busy area. But I think since we don't know the timing of the underlying alleged gun possession, being near the car is just of no real significance, because if in fact there was someone in that car with a gun, as far as the police knew, he could be anywhere on that block, or he could be a few blocks away.
The question isn't that there is no gun here, so it's not a question of gun possession. The question is what's an appropriate police response to that sort of anonymous phone call?
Well, right, and there are anonymous phone calls and there are anonymous phone calls.
You're suggesting, as I take it, you're suggesting they were permitted to do nothing.
Nothing vis-a-vis Mr. Hill. That's right. And at the very least, not, they couldn't act as if they had founded suspicion.
You're saying that they couldn't even ask him if that car was his?
That's right, Your Honor. I think that would be a question that would require founded suspicion. And just like they couldn't...
The fact that he's 3 to 5 inches,
3 to 5 feet
near it?
He's not touching the car. He's not leaning on the car.
There's
nothing connecting him to the car. And I just think that I think it would be a different answer if it were 3 in the morning and he was the only person on the street. But on a crowded street, I just don't, being a black man and being near something...
Would it be a different answer if the radio run of the 911 call included a description of a black man with a black hoodie?
Yes, that would be different. That would be, that wouldn't give you much because it's a pretty vague description, but that would give you, I think, arguably enough to ask those questions.
A moment ago you said a crowded street, but at the end there is no testimony of how many people and just where they are and who they were.
That there's people around, there's people on the sidewalk,
female.
and there is specific testimony that this particular intersection was a busy part of the area, a busy part of the command.
I think there was something, well, I know there was testimony that it was they patrolling the hot zones.
Right.
But I don't know what that means, whether that means criminality or whether it means, or what it means.
Well, he tries to define it, and so he does describe it in terms of a higher level of criminality, but he also describes it as a busy area in the command. And I think on a November evening, this is 154th and 8th Avenue, it's a block away from Rucker Park, and the officer acknowledges that this is a busy area, and I think we know that this is a busy intersection, and so that being a black man on that street shouldn't invite police approach, even if you're near something that's suspicious.
When was the alleged spontaneous remark made? Was it made before, when Cox approached? Did Cox say anything? What's the timeline of that?
The timeline of that, according to Officer Cox's testimony, is that it's when he's approaching. The officers say they're all approaching. They say they walk at a normal pace. They identify themselves as police officers.
Did they identify themselves before?
Yeah, he said they identify themselves as police officers, and that Mr. Hill purportedly says, did somebody call 911? Did somebody say I have a gun? And of course, he didn't have a gun, so it's a strange thing for him to say. It's a strange thing regardless for someone to say when the police approach. But it's
So they
particularly...
they hadn't begun conducting any kind of inquiry, correct? There was a spontaneous remark, and that's what sort of set off everything else.
Right.
Is that fair to say?
According to Officer Hill, it's a spontaneous statement as they approach, and they haven't said anything yet other than identifying themselves as police officers. But
So based on that remark, wouldn't that be sufficient then? I know you say it didn't occur, but
right, so two arguments. One, it's not credible that it occurred. Two, that even if it occurred, I still don't think it takes the description black male and gives you reasonable suspicion because he's not saying, I have a gun. You know, so at best, let's assume arguendo for a moment that he actually said that. Then I think the best interpretation is that, you know, he heard someone call 911 or he heard that someone called 911 and he's trying to defuse the situation. That's the only reason why someone would be motivated to say to the police, did someone call 911 on me and say I have a gun, is to defuse the situation. And so it falls in that situation of ambiguous evidence that shouldn't heighten the predicate, certainly not all the way up to reasonable suspicion.
Thank you. Thank you very
Your Honor.
much. Fisher v. VNO 225 West 58th Street.
Good afternoon. May it please the court, Patrick Lawless for the defendants, appellants, respondents. We respectfully request that this court overturn so much of the order appealed from as granted plaintiff's summary judgment on his Label R 241-6 claim based upon an alleged violation of Industrial Code 23-1.22B2. At the very least, there's issues of fact whether this makeshift platform constitutes a ramp or runway as defined by the statute. This was just a makeshift platform that was just...
Doesn't the code regulation also say that it's for use of persons only?
Well, it says for use of persons or use of wheelbarrows.
Well, it says persons, use of persons only, is what it says. Was this platform used for persons only?
It wasn't used for persons only. It was used for, it was just used to clear, there were 6-inch concrete curbs in the mechanical room, and it was just about 10 inches off the ground, and it was just used to clear that so A-frames and pallet jacks could be transported from the hoist to the
So
mechanical.
it's for the use of people in transportation of equipment, essentially.
Correct.
So you're saying, that's why you're saying 241, that section of the code doesn't apply, because it wasn't only for people, it was for transporting.
That code implicate, number one, I think it says ramps or runways. Runway's not clearly defined, but it's clearly not a ramp. It was flat, it wasn't on an incline or a decline.
So you claim it was a platform, right?
A makeshift platform.
Used to transport materials?
Correct.
Couldn't it be a ramp?
It wasn't a ramp because it wasn't on an incline or a decline,
Is
apparently.
that how a ramp is defined, that it has to be on a decline or incline?
I think that's just a common perception of a ramp. But according to the defendant's own expert, Mr. Lorenz, this particular provision of the code wasn't applicable, and this is after he reviewed the testimony and reviewed the photographs of the makeshift platform. Moving on, at the very least, though, the court should not have dismissed the defendant's affirmative defense of comparative fault. The plaintiffs, as the moving party, had the burden of coming forward with admissible evidence to establish that affirmative defense.
So, I mean, yeah, so they put in the plaintiff's testimony, right? And he says, I didn't do anything.
Well,
So there you go.
the plaintiff
Right? There's
testified.
nothing in there, there's no other evidence. Everyone testifies as to how the accident happens, right? There's no dispute about it. He steps on a part of the plywood that isn't secured. So, and he testifies, I did not do anything to cause that to happen. So there it is, there's the prima facie. What did you put in to raise an issue of fact?
The plaintiff's own testimony,
Let's assume that that the plaintiff puts in, the plaintiff's deposition testimony is, I didn't do anything, and let's assume that that happened. Did you put in anything, let me change the question then. Did you put anything in to raise an issue of fact on that issue?
it's the plaintiff's own testimony.
Okay.
Because the plaintiff testified.
What are you saying that, right?
The plaintiff testified was, at the time of the incident, he wasn't watching where he stepped. He was just looking straight ahead and wasn't paying attention to where he was stepping. So based upon that, at the very least, raises an issue of fact.
But what did he do wrong? I don't understand. What are you saying that the plaintiff did wrong other than not looking when he fell?
Well, any time there's an accident where somebody falls and is not looking where he's going, he could have perceived if there was where to step, or if he was stepping on a portion of the platform which would have made it tip over. So at the very least, he should have been looking where he was
No, but this was a loose piece, right? So you're saying he would have seen that this piece was loose by looking, so you're saying he should have been walking down and looking down, walking straight ahead, looking down, and he would have seen.
Well, he was walking on a platform. He should have, at the very least, looked at the platform and seen where on a platform he was walking.
I mean, did you really present this argument below? I mean, I know you're making it now on appeal, but was this argument presented at Supreme Court?
It wasn't presented in the Supreme Court, but as I said, it's the plaintiff that has the initial moving burden, and the plaintiff relied on his own testimony, and the argument is that his own testimony raises issues of fact.
So you're stating that if he had been looking where he was going, the plywood would not have tipped up suddenly, gave out from underneath his right foot, causing him to fall to the concrete floor. And if he had been looking where he was going, he would have known that the plywood was not properly fastened, right, secured to the framework.
I'm saying at least that raises an issue of fact had he been looking where he was going.
Thank you.
Thank you.
Good afternoon, Your Honors. May it please the Court. Daniel Maltese for Plaintiff, Respondent, Cross Appellants. Initially, judges, this is not a makeshift platform. This is a constructed plywood elevated work platform that was placed by a contractor for this job. It's a ramp in that it was used to transport material from the hoist through to the mechanic room, down to the subfloor. There's pictures in the record that show
With
the ramp.
respect to your 241-6 claim, and that's under 22B2, so it's ramps, runways, runways and ramps for use of persons only. Would you agree that this platform was used for more than people? And if that's yes, how does this provision apply?
Sure. At the time of this accident, it was only the plaintiff on the ramp. But there is a ramp component to this.
That's not the wording of the provision. The fact constructed for the use of persons only. This is not constructed for the use of persons only.
Judge, if you look up at 23-122B1, it says all runways and ramps shall be substantially constructed and securely braced and supported. That's first. Second, runways and ramps constructed for the use of persons only shall be at least 18 inches in width and shall be constructed of planking at least 2 inches. At the time of this accident, the plaintiff was working and walking across it. He wasn't pulling material. He wasn't pulling anything else.
No, but the statute doesn't talk about just the plaintiff, the minute of the plaintiff's accident. It's what's the purpose of the platform, and the platform here is not just for human use, correct? And that's what I mean. That's what the statute says. I mean, that's what the reg says. Only for human use, for lack of a.
For the use of persons only.
Right. Only.
Constructed for the use of persons only.
Correct, but the ramp itself is part of a larger system of plywood structure there. So we have a runway, which is not defined, and we have ramps that are constructed for this individual to traverse over water retention curbs.
I guess, counsel, what we're trying to get at is that it's pretty clear from the record that the structure was used for multiple purposes, including moving materials from the hoist to the mechanical room, I think. And so, based on that testimony, how can you say that it was constructed only for the use of persons?
I wouldn't say that it was only for the person. I would say
Well,
that
then
it was
isn't that,
constructed,
then how does this reg apply?
well, it rectifies in that the structure itself, the plywood structure falls under all of 23-1.22. Judge, it's a runway and a ramp. It was constructed for people at the time of the accident. It was constructed for this worker to traverse the water retention curbs. And he also testified that buggies and hand carts were pulled across.
But wait.
That's the
look-
point. It wasn't constructed for this worker. I think that's the whole point.
And you moved under that specific 23122B2, not just generally, because as we know, you couldn't move just generally. You had to move under that subsection.
Your Honor, I moved under the complete 23-122. The court focused on our experts' assessment that the ramp was constructed in contravention of 23-122B2, but the motion was directed under the complete industrial code violation of 23-122.
I thought it was.
if you look at-
I thought it was only under 23-122B2.
If you look at the court's order here, they make note that we asserted, get to that. Here, plaintiff alleges that page 7 here, plaintiff alleges that defendants violate industrial code sections 23-1.2, 23-1.2D, 23-1.2A, et cetera, all the way to 23-1.22.
Right,
in
but
its entirety.
the claim that the court ruled on was B2,
Right.
correct?
Correct.
All right.
Again, so the lower court should be affirmed because the images that are depicted in the progress photos that were supplied to the court, the lower court, do show a slope ramp. They do show a ramp that's for bringing people and materials from the raised elevated platform down to the sub.
Isn't this really, counsel, isn't this really a 200 case?
This is actually a 241-6 case. Because if the ramp, what ramp on any construction site is not going to be used to carry material through? I mean, the meaning of this industrial code, you're going to have this
It doesn't have, it's not a height differential, right? It's a flat platform. That's what the pictures show.
No, if you look at the record, and I believe it's 963.
I mean, I looked at all of them, I printed them all out. They show a flat platform, and no one testifies that there's any elevation differential.
Well, how
right,
else
on
would
where
you get from material from the?
No, but we're talking about where he fell. I mean, there might have been another part that had a ramp down. We're talking about
It's one
where he
plywood
fell.
structure, Your Honor. That's what it is.
Yes, okay, so there could be a 30, something, the room, this size of the room, and over there on the corner, there's a ramp. That doesn't make what we're talking about a ramp, right?
Correct, but that's not what happened here.
So we're talking about all the arrows in the photographs show a flat platform where he fell, correct?
Well, the plywood where the plywood
it
tipped
came
up
up.
was flat, correct.
It was
It was
flat.
an elevated work platform where he fell off.
Got it.
Correct.
Thank you.
I'd just like to very briefly address the Supreme Court's dismissal of the 240 claim. The court properly dismissed the 240 claim as the plaintiff here wasn't exposed to a significant height differential. The testimony was that this platform, which again was just constructed clearly to just clear the 6-inch curbs that were in the mechanical room, was at most maybe 10 inches off the ground. The photographs confirm that. There's no evidence.
Plaintiff says, and you would say that was upon prodding, says it was perhaps 18 inches to 24 inches.
Well, even if it's 18 inches, there's multiple cases cited in my brief that says that's still not a significant height differential. The photographs clearly confirm that it's not 2 feet. If you look at the photographs specifically on page 489 and
Yeah, but we don't want to
490.
get into deciding whether it's 10 inches or foot and a half or 2 feet, right? The question is whether or not 241 applies to these circumstances.
It doesn't, Your Honor. It's just an ordinary construction hazard, as the court correctly held, and not a
And this
significant height
wasn't a
differential.
safety device. And this wasn't a safety device.
No, and it wasn't a safety device. The plaintiff and his expert tried to compare it to a scaffold, but it's clear that it wasn't the functional equivalent of a scaffold in his case. And for the same reason, the court properly dismissed the plaintiff's industrial code claim premised on 23-5.1 as well. Thank you.
Thank you. Rudderman versus New York State Insurance? Oh, I'm sorry.
I'm sorry.
You did, because I asked if you had a code.
Okay, so with respect to the 240 case, judges, this is an elevated work platform. It meets the statutory definition of a scaffold. Work was being performed from on top of this scaffold. There was ladders being set up on top of it. There was work being done above the plywood structure. The idea that this is just a flat
But again,
platform-
looking at the photographs, I don't see how, I don't see any elevation at the point where the plaintiff fell.
Well, the elevation is that the plywood platform is constructed on top of these water retention curbs. By the defendant's testimony, it's 2x10s on top of 6-inch curbs with a 3/4-inch plywood on top of it, puts it at 16 inches by defendant's assessment. Plaintiff is working on top of this elevated plywood structure, and it gives way and collapses underneath him, sending him to the work level below, which was the concrete floor. So we have 2 levels of work being done in the mechanic room. We have the work on top of the platform, and we have the work on the subfloor. That's 2 distinct layers. Once the gravity-related hazard here, or the elevation hazard, is because the elevation device, and all parties agree that it was elevated. Counsel will claim it's 10 inches. We claim it's 1.5 to 2 inches. 2 disinterested non-party witnesses claimed it was 20 to 30 inches, which was not addressed in the lower court.
But under the circumstances of this case, where the accident occurred, could you really say it was a significant physical elevation difference?
You're on a 1.5 foot when you fall suddenly while walking across an elevated platform is going to cause significant damage, and our expert did those calculations and submitted them in his affidavit. But being reminded that this court has repeatedly held that there's no bright line height differential,
right? So
to
we look at
determine an elevation hazard. So we do have cases where there's 12 inches, where there's 18 inches, where there's 1.5 feet or better, and so on. That's why it is an elevation-related risk.
What is it that you're saying that your client was supposed to get that he didn't get? What was he supposed to, what was the non-provided?
A secure platform to walk across.
Oh, okay, okay.
You know, I mean, you can't have them walking next to something where there's a drop-off, and it just gives way and it fails.
Thank you.
Thank you, Your Honor. Thank you.
Rudderman v. New York State Insurance.
Good afternoon, and may it please the court. Israel Klein for Plaintiff Appellant. We have here interview notes from appellant's interviewer that documents the perceived age of candidates. This in itself demonstrates a material dispute of fact as to whether appellant was denied employment because of his age. As to candidate 2, Ms. Golden notes that he appeared to be in his early 50s, late 40s. As to candidate 11, appeared to be in mid-20s. But beyond this, we have 11 out of the 15 candidates were significantly younger than the appellant.
And we have a number who were actually hired, I think, who were the same age or older than the appellant.
Very few, Your Honor. We have 15 candidates that were selected for employment. 11 of those were significantly younger.
Okay, so let's assume that age played an issue in terms of awarding the positions. Was there not also a legitimate non-discriminatory reason for the refusal to hire your client, specifically that your client refused to respond to the questions on the application, that his application was incomplete. He did not provide details as to his past employment, and also that he was late for the interview?
Well, Your Honor, that's the pretextual reasons that respondent is offering, but we have a dispute of fact as to whether that's the true reason.
Well, was the application complete or was it incomplete? Did he not fail to, and I thought he admitted this as well, but did he not fail to state the dates that he was at Columbia?
Your Honor, the application did not require to list the dates of employment. The application asked for list the last 5 years of employment, which my client, the appellant, did answer and said, for the last 5 years, I was employed as an instructor at Columbia University. That question was answered. Yes, he didn't list every single employment prior to the 5 years. He wasn't required to do that. But even if he was required to do that, he attached his resume to the application, and one of respondent's employers directed him not to fill out that section.
But then the resume, I thought, was deficient as well because it failed to provide descriptions of his duties at his previous jobs or indicate how the jobs were relevant to the job he was now applying for.
Well, Your Honor, a resume is not deficient. The resume says I was an instructor. He's not required to specify.
The resume was deficient in that it did not provide the information that was required for the application for these positions.
Your Honor, the application only asked to provide the last 5 years of employment, which my client did, saying he was an instructor at Columbia University. It did not specify every single duty in that role, and frankly, an instructor, that's pretty obvious what an instructor's roles are. Teaches classes, prepares lessons.
I don't know what an instructor's role is. Yeah, I don't know that you can say that it's pretty obvious, but again, you're talking about an employer who is interviewing and obtaining applicants and application and information as to whether or not the individual is qualified for the position. I'm not sure why an employer would not be able to ask questions that were relevant to the position, including prior employment and how the prior employment would be relevant to the position that the person is now applying for.
Yes, Your Honor, an employer is more than welcome to do so and could have done that on the interview, and in fact did not do that in the interview, and that in itself raises an issue. But, Your Honor, in terms of the completeness of the application, could he have elaborated more and said his specific duties for each position? Yes. Does the fact that he didn't do that mean his application was deficient? No. Is that a sufficient reason to?
Yeah, but he was. It's not so much that he didn't do so and then he was not considered, and then his application was denied. He was requested to do so. And even though he was requested to do so, my reading of the record is that he still failed to do so.
Well, Your Honor, he filled out the information after his interview. But again, prior to the interview, the testimony in the record is that the employee of respondent directed him not to fill out that application. The application only asked for the previous 5 years of employment. His resume did specify what the previous 5 years of employment was, and on the application itself, he wrote teaching at Columbia University, Your Honor. If respondent wanted more information as to what his specific duties were, they could have asked him during the interview itself. He filled it out afterwards. And again, Your Honor, even assuming that's all true, there's still a question of fact of if that was really the reason he was denied employment. I understand that's what they're proffering, but we have notes from an interviewer stating the ages of candidates, Your Honor. And the court below also found that the fourth proffered reason for denying employment was false. So we have a reason that's demonstrated to be false here. Plus, we have 11 of the 15 candidates to be significantly younger than the appellant. We have missing information as to the other 3 that were selected, so giving appellant the benefit of every favorable inference, which we're required to do here. We have 14 of the 15 applicants being significantly younger than the respondent here, Your Honor.
Thank you.
Good afternoon, Your Honors. Kristen Holliday for Respondent Naisif. Supreme Court correctly determined that Naisif was entitled to summary judgment in this case. When Naisif—
What should we make of the fact that the interviewers indicated perceived ages on their notes?
So there was one interviewer who took notes about distinguishing factors or characteristics of candidates. There's a sworn statement by her in the record in which she says that the reason that she took those notes was to help her remember which candidate was which. In this case, for example, NYSEF was interviewing multiple candidates over 3 days, and I believe there was a weekend in between those interview days. So there's a sworn statement from her saying there was a benign reason for taking these notes.
Was she the final decision maker with respect to employment decisions?
So my understanding is that the interviewers, there were, I think, 11 of them, maybe even more in the
They
interview
voted,
room.
right?
And they did not vote. They hired individually for their own sort of departments, and they didn't discuss between each other.
Okay.
So that's something else that's in this woman's sworn statement, Ms. Golden, one of the interviewers, that she didn't share her notes with any of the other interviewers, and that the interviewers from all of the different departments did not discuss the candidates together. So Ruderman says that we can't believe Ms. Golden's explanation of her notes, but he doesn't actually offer any evidence that controverts it. And in fact, her account of the purpose for those notes is supported by the fact that one of the candidates she recommended hiring was somebody that she perceived to be in their late 40s or early 50s, and was actually, I believe, 54 years old at the time that they were hired.
Was there any, is it, no, I think it's not disputed that they were, though the plaintiff listed some references or people that they could call, that the defendant could not reach any of those listed employers, correct?
Yes, Your Honor. So as Ruderman emphasizes, and as my friend on the other side emphasized today, Ruderman said that at the time of his interview at NYSEF, for example, his employment with Columbia was ongoing. But when NYSEF contacted Human Resources at Columbia, not only did they say that they had never heard of Ruderman, but the person that he had listed as his purported supervisor, they were told hadn't been there in more than a year.
And that was undisputed. He didn't put in any evidence to dispute that evidence, correct?
That's correct, Your Honor. So that alone, inability to verify past employment, would be a sufficient reason to deny employment to Ruderman. But as Your Honors have also hit upon, it was more than that. NYSEF had many, many reasons not to hire Ruderman. None of those was because of his age. He submitted deficient employment applications. His resume, as Your Honors have alluded to, essentially just listed past positions with no information about how long he had spent in each role, and no information about what his job duties were in those particular roles.
So essentially, he could have been at each one of those jobs for 2 weeks.
That's right, Your Honor. And
there was no ability to understand whether or not he had been there for a year or 5 years or 15 minutes or 2 months.
Precisely. And there's evidence in the record that the interviewers relied on having that information before the interview, because the purpose of the interview was not to get basic details. Instead, it was to dig in a little further.
But he argues that he was told that he didn't have to supply that information.
He argues that he wasn't required to fill out the employment application completely. He does not argue that he had any reason or instruction not to include that kind of information on his resume, and he doesn't argue that his resume was sufficient to tell people exactly what his job responsibilities were. I also, just this is a minor point, but I did want to clarify because my friend on the other side brought it up, the employment application, once he decided to fill it out more completely after the interview, it does actually ask for dates of past employments. An example of that is at page 132 of the record. It does only go back 5 years, but it asks for the current dates, and that's one of the places where he indicated that his employment with Columbia was ongoing. In addition to all of the reasons that NYSEF had not to hire Ruderman, I also want to point out that the ages of those candidates NYSEF did hire, which included 7 people over the age of 40, including a 58-year-old and a 60-year-old who was the same age as Ruderman at the time of his interview, cuts against age discrimination here. The same is true with respect to the age of the NYSEF interviewers. All of them were over the age of 40, many of them were over the age of 50, and 2 of them were older than Ruderman. Finally, I do want to note that a credibility determination is appropriate on the specific facts of this case. Supreme Court below recognized that credibility determinations are appropriate only in rare circumstances, but this is such a case. Ruderman's testimony has been inconsistent on key details, and those are not limited to, quote, mere semantics, as I believe Ruderman said in his reply. So I just want to quickly walk through a couple of those important inconsistencies in the record. At page 341 of the record is Ruderman's EEOC questionnaire. That questionnaire asked him, quote, "What reasons were given to you for the acts you consider discriminatory?" Ruderman wrote a long answer to that question, and he did not say that he was explicitly told he would not be hired because of his age. When that accusation does come in the record, it seems like an afterthought. So at pages 354 to 360 of the record, there's this very dense 7-page typewritten account in small font all about his interview after he describes his rejection and after he opines as to how state agencies should hire. Only then there's a short handwritten note, it's not typewritten, it's out of chronological sequence, that said he was specifically told that he would not be hired because of his age.
And did he plead those facts that he was specifically told that in his previous iterations of this complaint in federal court? And you're saying he didn't plead it in front of the EEOC. Did he plead that in his complaint in the federal court?
So it's not in his EEOC questionnaire. That longer typewritten account, which has the handwritten note, that does appear near the EEOC questionnaire in the record. It's not entirely clear to me whether it was submitted with the EEOC charge, although the table of contents of the record suggests that it might have been. It was included in his federal complaint.
Included in his
That
federal
handwritten account, with the typewritten account, sorry, with the handwritten note out of sequence.
Okay.
I know that my time is expiring, so just quickly before I sit down, I do want to note Ruderman repeatedly insists on appeal that he was never asked about his qualifications during his interview. He also said that in an affidavit at page 651 of the record. But again, in his EEOC questionnaire at page 341, he said, quote, asked questions concerning previous related job experience, provided very satisfactory answers.
Thank you.
Thank you so much.
Your Honor, I just want to briefly note that there is evidence in the record from Mr. Ruderman's past employers that he was in fact employed in accordance with his resume, specifically Columbia University, and as a...
But did your client represent that he was employed, he was teaching at Columbia at the time, and when the defendants called, apparently that wasn't the case. Wouldn't that give them enough reason?
Yes, Your Honor, but the record is clear that they only called Mr. Ruderman's references or attempted to verify his employment after they marked him down as a non-select. They only went into that to try and mark him off the list for good so he couldn't reapply. But
And how do we know that? Where is it stated in the record?
There is an email, Your Honor, from respondent specifically says we're marking Mr. Ruderman as a non-select, but if we can verify that he's lying on his application, we can remove him from the list for good. So let's try and do that. That's clearly in the record, and I believe that's what the motion court relied upon to find that the fourth profit reason that respondent is providing is false, because they did not try to verify his employment as a process of making this determination, Your Honor.
Does he dispute the fact that what he said was false?
No, Your Honor. Mr. Ruderman maintains he was working at Columbia University.
Okay, does he dispute the fact, is there anything, did he put in an affidavit from the person he said he was working for, saying, no one ever called me, and yes, he was working for me. Did he dispute any of the facts that the defendant called his reference and the reference said, never heard of the guy?
Respondent never called appellant's reference because they didn't ask.
No, I'm asking you. There's undisputed testimony that that's what happened. Did he refute that?
Mr. Ruderman provided a letter from his employer at Columbia University saying that he was employed by that employer. Respondent never asked Mr. Ruderman for that employer reference to call him directly. They just called the Columbia number, got whoever they got, and said, we don't know who Ruderman is, and they said that's sufficient. But in the record, there is a letter from Mr. Ruderman's employer at Columbia attesting to the fact that he was working at Columbia. And in addition to the Columbia employment, there's other references from other past employment.
I have to, you're saying that the defendant just called the general Columbia number and asked, does this guy work here? Because that wasn't my understanding of the record.
They did not call a reference provided by Mr. Ruderman. My understanding is they called a number for Columbia or somebody at Columbia to inquire of Mr. Ruderman, but it was not a reference provided by Mr. Ruderman. And I think, and we made clear in the record that Mr. Ruderman said, and he wanted it, and this person, Tina, he said, can I provide references and numbers? And she said, no, they'll ask you for that if you want it. And he said, had they asked me for references, I would have provided it. But
it wasn't a reference. It was to determine whether he was employed at Columbia and the dates of employment. And I thought that what it stated was that he was not employed at Columbia at the time that he applied for this position, and he stated that he was currently employed at Columbia.
My recollection was respondent called someone at Columbia to attempt to verify that Mr. Ruderman worked there, and the person that they reached could not verify that.
Right, and
However,
that's normally human resources. I don't know whether they called human resources or not, But normally, if you want verification of employment, you would call Human Resources. But, you know, we have your arguments, we have your briefs. Thank you very much.
Thank you, Your Honor.
Vicari versus Shea.
Good afternoon, Your Honors. May it please the Court, Philip Young here on behalf of the NYPD. Supreme Court's decision ordering the NYPD to promulgate new regulations was error for two reasons. So first, Supreme Court was under the mistaken impression that the
What should we do here? Should we vacate the order and remand? What should we do here?
Your Honor, we're asking this court to vacate Supreme Court's order because it was erroneous for the two reasons stated in our briefs, and then remand to the NYPD for reconsideration of Vicari's application under the new regulatory framework that's been established post-Bruin.
And what's the status of that framework? Because isn't the Second Circuit hearing cases, at least with respect to the law?
Yes, Your Honor, there's certainly ongoing litigation going on about that, that regulatory framework, but the NYPD, that's the law right now, and the NYPD is applying it.
And that's how you're processing the applications now?
Yes, that's how we're processing applications.
You mean post-Bruin?
Post-Bruin, yes, correct,
Okay.
Your Honor.
Okay.
So the first error was that the Supreme Court here believed that the NYPD didn't have any regulations governing these special carry license applications by out-of-city license holders. That's not true. It's Title 38, Section 5-03, and Vicari effectively concedes that in his brief. And then the second error here is that the Supreme Court erroneously believed that, contrary to what the clear text of the penal law says, that the NYPD was essentially barred from applying the same standards to special carry license applications as it does to ordinary carry license applications. So as to the second error, that argument is really just inconsistent with the text of the penal law. Subsection 6 contains an explicit carve-out for the city that provides that these out-of-city licenses are valid anywhere in the state except within the city of New York, unless the NYPD issues a special permit granting validity. That's the language. So the language of the statute provides an explicit carve-out for the city. It allows the city to establish its own special permit process for reviewing these out-of-city licenses, and there's nothing in the text of the penal law that says either that the NYPD can't apply the same criteria to special carry license applications as it does to ordinary carry license applications. And there's also nothing in the text of the penal law that says that the NYPD has to apply this less stringent, more deferential standard of review to these out-of-city licenses. If the court has no further questions, I'd ask the court to vacate Supreme Court's order and remand to the NYPD for reconsideration.
Thank you.
Thank you, Your Honors.
Matter of Morris v. New York City Office of Administrative Trials and Hearings.
Thank you.
So, Ms. Morris, you have 5 minutes, and you can tell us as to why you believe we should reverse the determination of the New York City Office of Administrative Trials.
I believe that the ticket that was given to me was defective. I believe it was charged to the wrong statute, and I vigorously defended that. The officer who wrote the sum, I'm sorry, I'm just a little nervous. The enforcement officer took my valid mobile food vendor license, and he also took my mobile food cart permit. And and I quote, in the ticket, he said I was a mobile food operator, and he observed me vending food goods from a mobile food cart. That in itself tells you that I'm not a display stand. To bolster my defense, I also prevented, I thought was very powerful substantive evidence in the form of 4 decisions by 3 different administrative law judges, and I quote, "The respondent was vending from a mobile food processing unit pushcart and not a display stand." Another, "A clear reading of the statute fails to prohibit food vending push carts from vending." And one that stated very clearly that the statute fails to prohibit food carts from vending in a bus stop. And this particular hearing officer disagreed, and I I never got to argue the bus stop. Instead, he ruled that my mobile food vending processing unit is a big push cart. It's 8 by 10, and I cook food in it. And it weighs about 2,000 pounds. He basically automatically assumed or presumed I was guilty of vending within a prohibited location based on unproven information that the agency's representative could either deny or admit to observing. The enforcement officer wasn't even at the hearing. So the sole basis for issuing me the ticket was to justify a summons, and on that, as I said, I believe that that was a defective ticket. The charge under Parks rules. Parks does not set the standard for my mobile food processing cart. This court in Morris also agreed with that the health department has the statutory authority to determine the criteria for mobile food processing units, push cart. And on that basis, I believe that I'm correct. I looked it up and I appealed the decision. And even though they contain similar words, the health department makes it very clear that a stand is other than a vehicle or a push cart. It makes it clear that it's other than a push cart or a vehicle or otherwise propelled. A mobile food vending unit shall not mean a stand or a booth. They separate them very clearly with the Parks rules, with the display stand, and as far as the licensing and permitting of a push cart. They're very separate
So
and
what is
distinct.
it that you're arguing that you have? Do you have a display stand? Do you have a push cart?
I have a push cart. My
have a
push
push
cart,
cart.
my push cart, yeah. A display stand, the health department doesn't license or permits display stands. They permit very strict criteria for food carts, according to the health code and Title 17 of the administrative code.
And
I cannot
they claim that this was a
display stand under
display
Parks
stand.
rules, and I said Parks doesn't have the statutory authority to determine the criteria for my equipment. There was never a dispute. They can enforce location, but they can't. They have no jurisdiction over the equipment that is being used.
Why isn't your push cart, why wouldn't it fall within the definition of display stand?
Well, according to the health department, that
Do you display food? Do you display food that you're going to sell? Well, hold on. Do you display food?
I can, yes.
Do you? Not you can.
No, I don't. I don't display it. I cook it.
But you're selling ice cream and water. You don't cook either one.
I was making chicken kebabs, hot dogs, knish, pretzels, French fries, chicken nuggets. Trying to think of chili cheese, basic food cart.
Thank you. You have time on rebuttal.
Good afternoon. May it please the court. Jeremy Pepper for the New York City Administrative Office of Trials and Hearings.
Okay, so your position is that this was a food cart?
Well, our position is that it was a display stand, and under the definition of display stand in the parks rules, a food cart would fit within that definition. The definition is.
How so?
Well, I'll read you the definition. It says, for the purposes of this section, a display stand shall mean a movable, portable, or collapsible structure, framework, device, container, or other contrivance used by a vendor in any property under the jurisdiction of the department for the purpose of displaying, keeping, storing any goods, wares, merchandise, or foodstuffs.
Does her food cart fall into storing goods?
Well, foodstuffs, certainly, and that's part of the definition.
Isn't that a forced application of that definition?
I mean, I disagree. I just read you the whole definition, but I can shorten it. For the purposes of the section, a display stand shall mean a movable structure containing foodstuffs. She admitted at the hearing that her food cart was movable, and she was selling ice cream, and she just listed a whole number of foodstuffs that she sells from there.
That she cooks.
Cooks and sells.
But I thought that there was a different definition of the article, the food cart or the push cart or whatever, where the items were cooked.
Right, and appellant in her brief cites to various provisions of the health code, which may draw distinctions. That code, of course, governs a complete.
Right, she argued that the food cart was not a display stand because she could use her cart to cook and process food. And she just talked about chicken nuggets, et cetera.
And within the health code, which that might be true, and the health code governs various behaviors, governs food safety and the procedures by which people are allowed to serve food. Respectfully, that's not at issue in this case. What's at issue in this case is a parks regulation that tries to keep bus stops clear from obstructions, which is important for the safety of people trying to board buses and for the flow of bus travel. So the code here, though it uses a similar term to terms used in the health code, display stand is clearly defined for the purposes of this statute as a movable structure storing foodstuffs. So although the appellant might cite to other statutes that use that term differently, respectfully in Heard v. Cuomo, the Court of Appeals has said that if different statutes use terms in ways that are not contrasting, both statutes may be given full meaning. So I just want to quickly pivot back to the standard we're under here is, first, the oath's decision was supported by substantial evidence. I don't think any of the facts here are really in dispute that the appellant was selling foodstuffs from a movable structure at the bus stop. And furthermore, the officer's ticket itself can provide substantial evidence, as this court has held. But furthermore, oath's decision was rational or reasonable and in accordance with applicable law. Oath's interpretation of 105B6 to include Morris's mobile device was within that her mobile device was within the definition of display stand is reasonable and entitled to deference. And she has provided no reason why this court should overturn that finding. Just quickly to address the prior decisions, because I know Ms. Morris brought those up. I just want to note only one of them was attached below, but I've been able to track down all four. All four are hearing decisions. None of them were appeals decisions, both appeal decision. And respectfully, they have no precedential value. But even looking at the substance of them, not one of those decisions went past 105B53 to 105B6, which contains the definition. Not one of them addressed the definition of display stand. And so respectfully, those decisions are all superficious and should not be given any weight. If there are no other questions, I'll rest on my brief. Thank you.
Thank you. Yes, Ms. Morris, you have 2 minutes to.
The ticket, the enforcement officer didn't list everything on the ticket that I sell, by the way. But I just want to make it clear that I followed this court's ruling in Morris versus the New York City Department of Parks and Recreation Op. 02762 dated April 11 that clearly stated unambiguously that while Chapter 21, Section 533A1 of the City Charter gives parks the statutory authority to regulate certain activities within its jurisdiction, such as where a vendor can locate, it does not divest DOMH, the Health Department, of its powers to regulate mobile food vendors. DOHMH, the Health Department, licenses mobile food vendors and food vending carts in New York City under Chapter 22, Section 551 of the Charter. That's indisputable. I followed this court's ruling in Morris. I followed every provision of the Health Department to construct my mobile food vending unit. It was licensed. It's almost akin to saying that
Were you parked at a
a
bus?
go-kart is the same as
Were
a
you parked-
licensed vehicle. It isn't.
Were you parked at a bus stop?
No, I was parked curbside on the sidewalk, sir. I was not within a bus stop.
So are you on the westbound?
And I couldn't argue
Are you on the
that-
west side
I'm
of
on the west-
86 or the east side of?
I'm on the west side.
You're on the west side.
Yeah. I couldn't argue the bus stop.
So there's no bus shelter.
violation. I'm
There's
sorry.
no bus shelter there, right?
No,
There's a bus shelter on the east side, but there's none on the west side, right?
I can't.
And so the ticket states that you're in the bus stop on the west side.
And I couldn't argue that because it was first had to be determined what it was that I was, because I believe that the basis of that ticket was wrong, that it was not, I think you call it prima facie, that it was written incorrectly. If they wrote the ticket correctly, then I could argue the bus stop. But why would I argue the bus stop? And that means that I would agree with them that my cart is a display stand that is not permitted or licensed by the health department. That would leave me so vulnerable. And frankly, to be honest with you, I was just tired of being harassed. I was adjudicating 4 tickets. 3 of them were even dismissed because they were just writing tickets. They go down the line and they write the tickets, and they don't always get the law right. And as vendors, we have to protect ourselves.
Thank you.
As licensed vendors.
As licensed vendors, thank you. Thank you both.